members are present with the respective attorneys. Ms. Gorsline for the plaintiff, Mr. Khalifi for the defendant. This is a motion filed by the father regarding parenting time. In effect, the essence of it is that the child, who is almost 16, is now in high school and involved in some extracurricular activities. What? Oh, all right. Including at this time track, maybe sometime in the future soccer and stuff like that. And apparently, I know that Miss Emery has every other weekend. They meet in Michigan City and stuff like that. But some of the track meets and stuff like that are apparently going to interfere with some of her parenting time. And I'm left to try and figure that out, what to do with it. Is that about it, Mr. Khalifi, in short?
Yes, good summary.
Yes. Ms. Gorsline, I've read everything in this, but clearly I'm going to allow the child to participate in track meets.
Yes, we understand that, Your Honor. I think really and I've been talking with Attorney Khalifi and we're working to get something out. My client's been really working even prior to this motion with Mr. Emery, and they were trying to reach recordings. What's been the issue is just the number of weekends in a row. So we're working on a schedule, well, two parts. One, we're working on, moving forward, how do we address these issues? But second, for the rest of the year, this track schedule, getting that worked out.
This is absolutely, it's almost word for word what Shade says, the case of Shade. And the minor child, in Shade, was in high school, desired to participate in more social and extracurricular activities. Parties lived far apart. And if I need to, I'm going to change parenting time to accommodate the child. The child's the innocent one in this. I don't know that your client, Ms. Gorsline, is going to get day for day or night for night that she misses. She does have, you can come up and see some of this and things like that. I want what Mr. Khalifi, what do you want as an order? He has the right to participate in school activities. Quite frankly, that's what he's going to be allowed to do.
I have a proposal, Your Honor. Yes, I appreciate that, and I appreciate the instruction that you've given so far. I would say that on Miss Emery's weekend, that they would meet after the extracurricular event, and then she could have the parenting time in Chicago for, it'd be Saturday overnight. The train that we propose that they meet for leaves the station at 6:51 p.m. on Saturday. In other words, the meet could conclude or the soccer game could conclude, and then Mr. Emery will bring the child down to Michigan City where they meet, and they will exchange on the 6:51 train. And that would be on her weekends.
And then any other time that you're going to allow outside of that, since she's going to miss her Friday night?
Also done for every week. Yeah. I think that it is an elegant solution may be to say that anytime there's a gamer meet, because we want this to be done, we want this to apply now and also in the fall when it's soccer season. I think the solution would be that anytime there's a gamer meet, Mr. Emery would have Friday overnights, and then they would meet at 6:51 p.m. on Saturday for an exchange, and she would have Sundays, and that would be every week that there's every week of the season, basically. Then, in essence, she doesn't lose any time.
So you're proposing that whether there's a meet or not, she gets every Saturday overnight through that season?
Yes.
Well, Ms. Gorsline, that's about probably the best you're going to get, since quite frankly, I'm not going to stop that young man from being there. However, Mr. Khalifi, if there is not a meet or something,
right,
time should occur regularly, and Mr. Emery should know what the schedule is at the beginning of the year. I mean, I had kids in sports, and they know what the schedule is early on.
Yeah, yes, and this is where it gets tricky. Like, you don't know if there's going to be, or how those weekends will fall and all the rest of it. That was just the most simple solution I could say. And the reason it may even go every weekend is just so that if things fall that she wouldn't have any weekends, then it just would work out. It would just even out the time basically. So I guess the goal you could say in the order would be to provide for roughly the same number of overnights by doing this, by having it so he has Friday overnights during the entire season, she has Saturday during the entire season, with flexibility for holidays and days there aren't games. But for this to work, even if there's not a game, like let's say there's a weekend off, that still it may work out that you'd still follow this just to keep the overnights roughly even.
I mean, if she again, I say, you'll know the soccer schedule, you'll know the schedule at the beginning of the year. All right. And you'll be able to figure out if they're playing on weekends or if they're playing on Tuesday night, then it doesn't affect it. If he has a game or some, I don't know how I want to say it, some activity with the team, he's going to be allowed to do those activities. As far as providing for some type of makeup, that's their offer. Ms. Gorsline?
Thank you, Your Honor. My client, in regards to the one overnight, she is asking that if that is the case, that then he go back on the same train so she would have at least 24 hours. One of the issues is he goes back, I think it's by 4 o'clock. So by the time he would get there on Saturday night, it would be a pretty minimal amount of time. So just asking that she'd have a full 24 hours.
Oh, the train arrives at 6:51 in Michigan City?
That's my understanding. Can I ask my client to clarify that, Your Honor?
Yes.
Ms. Emery, you've heard about the trains. Can you explain about that?
So there's a train on Sunday that goes back around 6:36, I think is the time. So at least he'd have a full day. I agree with.
I want to interrupt because I want to say it leaves at 6:36 or it arrives in Michigan City at 6:36.
It arrives in Michigan City, sorry, about 6:36.
Then that's the train.
So it would be at least, so it'd be about 2 hours later than the usual, but
Mr. Khalifi,
that way he'd have
I understand it's getting a little late, but he is 16.
and
And
it's the holiday schedule that we use for holidays.
it's approximate. So
yeah.
if the two of you want to put together an order, like I say, that I am going to enforce that the young man is going to be able to do whatever school activities he has to do. And if it affects parenting time, I urge the parties to work together to try and figure out something. I know, look, I've had this case over and over and over again. So I know this isn't great, the parties working together. However, with the instruction that says he's going to be allowed to do that, we can do where he has every Saturday during the seasons. And if that's what works out, great. And he'll return at that 6:30 type Michigan City time.
Your Honor,
Your Honor,
and I have a few additional things to address. I believe this weekend, Ms. Emery's coming up. We could confirm that. That would be good for the meet. And then I also have an additional motion to make.
You have an additional motion that was not before me?
That's right. And I've definitely provided plenty of notice of it. I asked Ms.
Not to me, you didn't.
I know to the other party, though. She knows what's coming. I am asking for this pleading to be stricken. This response, I understand this has been a very contentious case, but referencing abortion when the child is 15.
Okay, hold on a minute. I agree that it's garbage to put in there that, and I moved there but nobody's going to read this thing. I'm not going to necessarily strike it, but I will tell you, Ms. Gorsline, that when I read that, I was offended. All right. Because it has nothing to do with this 16 years after the kid was born. That's just an attempt to go back at stuff.
Noted, Your Honor.
I'm not going to strike it, but you hear what I'm saying. That kind of stuff is so far garbage in the past that it was completely inappropriate.
I do hear you, Your Honor. I understand. May I address one other thing about the parenting?
I got a lot of motions. Fire away really quick.
I'm sorry, really
No,
quickly.
go ahead. Go ahead.
Other than the schedule at the beginning of the year, my client had been fine with 3 weeks notice because some things come up that you don't know in August, that happen in November, whatever. So I would ask that would also be included in the order.
I don't know what you're talking about.
Just for school activities that come up other than are known at the beginning of the year, like the soccer schedule.
Mr. Khalifi, this is straightforward. Your client has to understand it. When he gets information about school activities, he's to provide it promptly. Although Miss Emery probably has the ability to go on the school portal and probably find out as fast as Mr. Emery does. Other than the son will come home and tell Mr. Emery and he'll look. But I just want it to be that when he finds out if there's a soccer after the season thing and they don't schedule it till a week beforehand and it's going to be on a Saturday, he must inform within 24 hours of it coming out. All right, that's about the best I can do. I can't make him give 3 weeks notice on something he might not have 3 weeks notice on. These are kids and they're going to school. I've had them and I've gone through it. This is not rocket science. You understand? I'm assuming, Mr. Emery, you understand what I'm saying.
Yeah, I think he's doing that already. So that's
all right. That's fine. That's fine. All right.
Thank you, Your Honor.
Anything else? Good luck on Mr. Khalifi putting together an order.
Thank you, Your Honor. Appreciate that. Have a nice weekend.
You too.
Thank you.
Thank you both, everyone.
Thanks, Gracie.
This is a matter of Brooks v. Booker. Ms. Van Dyken is present for the plaintiff. Ms. Brooks has a married name now, and Mr. Booker is also present. This is a motion filed by the plaintiff, I believe, for specific parenting time. There is no specific parenting time in this file that I know of. There was a judgment of support entered in April of 2018. It was ultimately, support was suspended for a while, as I believe the parties tried to reconcile, but there's nothing specific. And if there's a request for specific parenting time, the court has to grant it. Ms. Van Dyken, is there anything you wish to say on behalf of your client? I believe it's her motion.
It is her motion, Your Honor. It is just strictly for that specific time. The parties had been working together somewhat, but there have been some concerns with regard to the minor child getting to school upon release from school, some physical altercations at Mr. Booker's home. He has experienced some anxiety and not being able to concentrate in school. So my client wishes just to have a set schedule every other weekend, Wednesday evening for Mr. Booker. The child can go to school throughout the school week. When Mr. Booker has had the minor child on like a Thursday overnight, he's unable to get the child to school. So my client has to make arrangements to pick the child up, take him to school, and then pick him up after school. Mr. Booker apparently doesn't have reliable transportation or assistance. So we're just simply asking for that. If there's a summer parenting time schedule, we could just keep the schedule and award each party 2 weeks for summer parenting time. But there does need to be some set schedule that can be enforced. Thank you.
All right, Mr. Booker, what have you got to say?
Yes, we have been working together, we had a schedule agreed from Thursday to Sunday. I have no problem getting my son to school on Fridays or any other day of the week. I do have reliable transportation, and I've always had reliable transportation.
So if the school pulled the records, they would not find any late times that your son gets there on days that you have responsibility to get him there. Is that correct? None. Exactly.
I wouldn't say none. I'm a parent, but no,
I'm
nothing.
a parent too, and my kids got to school on time.
Well, yes, sir. None. Yes, I can get my child to school. I have got my child to school on time and picked them up on time as well. I've always had reliable transportation, sir. More than one vehicle, to be honest. My fiance has a vehicle, so do I, and I'm allowed to use my work truck if need be.
What's your response?
I agree with Mr. Booker, because my client has to be the one to pick up the child on Friday mornings and then pick him up from school. So he probably hasn't been late, but my client has to do all of that. And
How many times has she done that, like this school year?
Probably
For
50% of.
Yeah. How many times have you done that this year?
I'd say maybe on 5 different occasions. On that Friday morning when he's supposed to get him to school, he cannot, and I am told last minute in the morning, so then I have to either leave work or
You have to ever call him to get your kid to school on time?
No.
All right. I can do one or two things. I'm going to set up either a temporary parenting time schedule here and send it to the friend of the court for further evaluation, or just set a permanent one. I think at least at this point, normal parenting time would include every other weekend from Friday after school till Sunday night at, the child's 7 o'clock maybe would be a good time. In addition, he will have every Wednesday evening. Has he exercised overnights on that Wednesday? Is
Yes,
there-
sir.
Thursdays, Your Honor. He didn't have Wednesdays.
All right, well,
Some Thursdays.
but he has that Thursdays. He can have every Wednesday from evening until gets him to school Thursday morning. I'm going to tell you right now, the first time that kid does not get to school on time, or you have to call her to get the kid to school on time, I'm going to change that to just having Wednesday evening. All right. I mean, I understand that if there's a snowstorm and
Right.
things like that, that's one thing. But other than that, your priority is to get your child to school on time without having to call. You say you got a girlfriend there, even somebody's going to get.
Yes, sir.
That's what you're going to get.
I've never had to call her to get my son to school.
Look, if somebody's not telling me the truth, and I'm not going to be able to figure it out here this morning. I'm just telling you. You know, you'll have every Wednesday overnight. All right.
Right.
And
Yes.
we'll
May I
get
add
child to
something?
school.
May I add something?
What?
If this is true, then well, a couple weeks ago, Jamie insisted that I keep my son for an entire week because of his behavior at her house and his behavior at school. And I did that no problem. And at one point in time, was he late that entire week, sir?
I didn't.
And she.
I am not finding on that one way or another. How are you moving the ball forward with this? Okay, I'm giving you time, and I'm just telling you, make sure the kid gets to school on time. I'm not taking your morning away.
Okay, no problem, sir.
I'm just telling you, get the kid to school on time. I don't know whether or not you do or not. I'm not ruling on that. All right.
Okay.
Yeah,
Okay, no problem.
Every other holiday type time for the, 9 till whatever, 7, 8 o'clock at night. Just normal parenting time for that. Every other holiday.
That's fine.
And I'm going to give each of you 1 week in June, July, and August in the summer. All right, a full week. It will include parenting. It will include the weekend in it. Okay, it's not going to be. You're not going to get a week plus your weekend. So each party can do something with the child and for a week and go on a vacation in June, July, and August. Everybody,
Yes,
they will notify the other party by May 1, their chosen weeks. If it conflicts, even years, Mr. Booker gets to choose odd years. Miss Brooks gets to choose. She gets the time. Miss Van Dyken, I'm kind of relying on you because you know what I'm saying on this there. It's a very standard type of thing. Any other time that you guys agree upon is fine, but I'm going to tell you right now, if you agree upon it, you better have something in writing that goes between you.
I have something in writing now that proves that she agreed upon it beforehand.
But I just said, if you're going to deviate from this, you guys can parent the way you want. If you get along, you can parent the way you want. But if you're going to deviate from this schedule, I don't want you coming in saying, hey, she said this, and she comes in and says, no, I didn't, and that kind of stuff. If you're going to deviate, then put something in writing that you both sign. Other than that, this will be the parenting time schedule, unless anybody wants me to send it to the friend of the court, of which it'll cost each of you $150 to go there too. I don't think the friend of the court will do much different than this.
Okay.
This will be the order. Ms. Van Dyken, can you draft that, please?
I will draft it, Your Honor. Thank you.
All right. Anything else?
So do the weekends that we have start with me this weekend and him next weekend, or how do we figure that out? Just between them?
Who would normally have this weekend?
Me, I have them now.
And technically,
normally he would have this
Jamie, let's
weekend.
just start this weekend with Mr. Booker.
Yeah.
And then we'll rotate from there.
Mr. Booker, you'll have him this weekend.
Yeah, I have him now. Thank you.
Isn't he in school?
Well, he's been sick with a stomach flu, but so he didn't go to, right, Jamie? He didn't go to school the entire week from your house, right?
he went on Tuesday, but his teacher excused him because he wasn't feeling well in class.
All right. Mr. Booker will have this weekend and we'll start from here.
Okay.
All right. Thank you.
And we can start, the first holiday is probably going to be Memorial Day. Ooh.
So just for clarity, sir.
Have more Memorial Day and it'll start after that.
Okay. So for clarity, so sir, I have him every Wednesday and then every other weekend?
Yes.
Okay, sir.
And who's going to take Memorial Day?
It doesn't matter to me.
Does this include birthdays as well? I'm so sorry to interrupt.
It does.
Okay.
All right. Pick that. That'll start the rotating schedule for holidays too. Good luck, everyone. Thank you.
Thank you.
Thank you, sir.
6DS Quaker versus DeBarkey. Both parties are present, as well as the Kent County prosecutor, Mr. Hahn, and Mr. Keeler on behalf of the defendant. This is the request from the prosecutor's office to enter a judgment of support. There is even a deviation addendum that has been proposed, ending up with the Defendant, I believe the amount requested at this point is $134 a month at this time. Miss Dehan, is there anything you'd like to say?
Briefly, Your Honor, thank you. This case was filed on February 1st and service was proper on the defendant on February 15th. We did receive a response that same day. I did hold a pre-hearing conference with the parties, Your Honor, on March 14th. I did collect their information. I do believe that the documentation is appropriate, as well as the imputation for the defendant. I did give him a generous deviation of $150 for providing daycare, essentially daycare for the minor child. I do believe the documentation, again, is appropriate, and I'm requesting that the judgment of support and UCSO be entered today. Thank you.
All right, I have reviewed everything, including the deviation and the imputation. Mr. Keeler, what would you like to say on behalf of your client?
Just very briefly, I guess generally we could say we have no problem with the order being entered. We would just ask that an immediate referral to the front of the court on the issues of custody, parenting time, and child support just be made right now. That's all. So other than that, no general objection.
So we'll enter the order. Pete, there's nothing timely about the request for custody, parenting time, and custody and parenting time being referred to the friend of the court. Ms. Hahn, you don't really represent Ms. Koiker either, okay?
I don't. I represent the beautiful state of Michigan, Your Honor.
Yes. So Ms. Koiker, can you unmute for a minute?
Yes, Your Honor.
Normally, you're entitled to some notice about such a request on a motion day of whether they're going to send it to the friend of the court for custody and parenting time and stuff like that. And I'm going to hold Mr. Keeler to that unless you agree that we'll send it to the friend of the court and let them take a look at custody, parenting time issues, because sooner or later I am going to have to establish parenting time and custody. I'm sure in the support order tells me that you get it probably initially without prejudice to determining custodial rights. The bottom line is it's probably the best thing to send it to the friend of the court, but I'm not going to force you right now because you don't have notice of this hearing. But if you have no objection to it, we'll send it off there. Both of you look really young, and I don't think there's a lot of income here, so I will waive the fees for that. And again, I don't want to force you into it because you may want to hire an attorney or something like that. But the bottom line is if Mr. Keeler files a motion 2 weeks from now and requests parenting time, custody, I'm going to have to figure it out somehow, and we'll probably send it to the friend of the court ultimately. That's a nice way of saying you don't have to agree to this, and I'll make him jump through hoops, but I'm not really sure that it's gonna provide anything.
Thank you, Your Honor. Yeah, I'm not too sure, like I've never done this before, so you're saying that if I object to it today, you'll make Mr. Keeler go through hoops for the...
Yeah, I'll make him file a motion asking for custody and parenting time for Mr.
DeBakey, Your Honor.
DeBakey. I'll make him do that. We'll come in. We'd probably do some kind of a temporary, and unless the two of you can somehow agree on stuff, which you can still do after this, I'm going to have to at some point do a custody parenting time order out there, okay? Because you have temporary custody right now in the order, but all they got to do is say, I want to I want to see about custody, and I have to. Because it is custody granted to you is without prejudice. They can ask and they don't have to jump through any hoops to get there. Same thing with parenting time. I got to have a specific if it's asked for. So I'm really trying to gently urge you to say, let's just send it to the friend of the court. Nothing happens to you bad at the friend of the court. They're just going to make a recommendation. And then if you object to the recommendation, you can file an objection, and then we end up having a big custody parenting time hearing. Okay. But if you agree to it and everybody does, that's something also that you can agree to, and we can get an order entered. So I'm being legally nice to you by saying you don't have to, but I'm trying to push you into saying, let's just move this along. How old is this child? 2?
Yes, he's 2.
And maybe you guys can even agree on some kind of a custody, especially working with the friend of the court. You might be able to. I don't know how are you getting along? And so it sounds like you kind of get along because Dad provides a significant amount of daycare time, and that's why he's getting a deviation.
Most definitely.
So, you all right with me referring it to the friend of the court?
Yeah, is there one thing that I could say before we go ahead with that?
I'll let you say one thing, but I got a lot of emotions.
Yes. I just wanted to state that before I applied for child support just recently, I consistently had Bellamy 5 nights a week while Jeremiah had him 2 nights a week. After we met Yasmin, Jeremiah, he makes a schedule every week because his school schedule and his work schedule can change often, whereas mine stays the same. I have it on recording that Jeremiah said with him having Bellamy 3 nights a week. So after we met Yasmin, that's when Jeremiah started making the schedule for Bellamy to have, or for Bellamy to be with him 3 nights a week and be with me 4 nights a week. And I have it on recording Jeremiah stating that this is, since this is closer to 50-50, it would prevent him from having to pay child support. So yeah,
Well, it doesn't necessarily, I mean, even parties who have 50-50, I'm just giving you a quick thing here. Mr. Keeler can tell his client this, but I can tell you that 50-50 doesn't mean that there's no child support. Child support is based on incomes, number of overnights, insurance, daycare. There's a number of factors. You feed it into the computer and it tells me what I'm supposed to do. And it's very, very hard to convince me that I'm not supposed to do that. There are deviations, but very few. So I think the best thing to do is to send it there. Let's see what it comes out with. Mr. Keeler, I'm sure you'll tell your client that just because they get 50-50 or what doesn't mean, I mean, he's paying an incredibly low amount right now of child support. All right. And so that's just the way you got. I'm hoping that you guys are going to have to get together for the rest of your life with a 2-year-old. All right. You just have to figure it out, and you don't have to like each other even, but you got to act in the best interest of this child at all times and not make put the child in the middle. So I'm going to refer it to the friend of the court because I'm going to take Ms. Koiker's nodding her head as saying that's okay. We'll send it to the friend of the court for custody. Even though there is a support order right now, maybe based upon whatever happens as far as the number of overnights and whatnot, I can't remember what the number of overnights right now is considered 104, depending on where that comes out. We'll do the friend of the court for custody, both legal and physical, as well as parenting time. And by default, I guess we might as well send it for child support and see what that comes out with also. But we will enter this order from the prosecutor's office promptly. When it is sent to me by DocuSign, it's effective February 1st. Be a little bit in arrears, but just work on it. All right, Mr. Keeler, anything else?
No, I mean, I guess I would just say, I mean, other than just kind of a general objection to kind of hearsay that the opposing party kind of brought up here, it's just my client's concern is just he's in school full time right now and is limited in how much he can earn. But yeah, but overall,
a general objection. I don't even know what the heck that is. Everything is fine. I've listened to her and basically I've just avoided your client having to pay for a motion and drafting it and all that kind of stuff, and he should be more than happy right now. All right, Mr. Hahn, I'll listen to anything you have to say.
Just briefly, Your Honor, since we did not receive Mr. Keeler's notice of appearance and it was placed on the record today, the documents don't have his information on the caption. I will send them to you as proposed without his information, but we will send a copy to Mr. Keeler rather than Mr. DeBakey.
Thank you so much. Yep. And we'll get that appearance filed as soon as possible, like today, actually. So
All right. Thank you, everyone.
Thank you so much.
I wanted to please try and figure this stuff out because you got a 2-year-old child and I don't want you to start out fighting. Right. Good luck. Thank you.
Thank you so much. Yep. Bye-bye.
Your Honor. Have a great weekend, Your Honor.
You too.
Thank you.
Thank you, Your Honor.
White v. Lester. We have Mr. Lester. Are you there? You're on mute if you are. Is it show he's connected? Yeah. Unmute, please.
Can you hear me?
Yes. Can't see you. Is there a reason your camera's not on?
No, there's no reason.
So you're gonna turn it on? There you go. All right, we're here. As I've said, White versus Lester, both parties are present via Zoom, and the prosecutor, Ms. Brower, is also present. This is a date and time set for the request to enter a judgment of paternity in this case. Ms. Brower, is there a DNA test?
Your Honor, the defendant did ask for genetic testing in his answer. However, he called the office on February the 14th and stated that he no longer wants testing. We again discussed testing. It came up at the March 28th pre-hearing conference, and he again indicated that he did not want genetic testing anymore.
Mr. Lester, you're willing to accept the judgment of paternity here then that makes you the legal parent of Zion, is that correct?
Yes, sir.
I mean, you're not gonna get testing later. This makes you the father and gives you all kinds of rights. You understand that?
Yes, sir.
All right, then, Ms. Brower, we can enter that judgment of paternity then, because I assume that Ms. White does not object to that also. Ms. White? He's the father?
Yes, that's it. Yes.
He's the father. There's also a request for an order of uniform child support. Going through that. The amount appears to be appropriate. We have Mr. Lester with potential income. He does have a work history, GED, believed to be available for work. There's virtually no unemployment in the Grand Rapids area. He's imputed at $16 an hour times only 35 hours because I don't know why he couldn't earn that. Mr. Lester, are you working right now?
The last time I had this meeting, I had lost my job. It was 2 days before I had the meeting. I'm currently looking for work right now. I haven't received any calls back, but I've been on Indeed since that day, just looking for work.
Got to find it. Go to McDonald's and get $15 an hour if you need to, or whatever. You have any objection to? I'm going to enter a UCSO. I'm going to enter a child support order. Do you have any objections?
Do I have any objection?
Yeah.
Yeah, I'm trying to figure out like how can I pay for something a month when I have rent to pay also, but the lady told me that something about the state allows her to do something. But
State of Michigan tells me that unless you are completely disabled and you show that you're disabled, I'm going to make imputed income. You have to work. I understand you have rent. You probably have, you got food, you got whatever, gas and whatnot. But what happens is we feed the amount that you make or the imputed amount, which I think the imputed amount seems more than reasonable right now, into the computer. We put in mother's income. And if she doesn't have any, we impute income to her. Did you impute income or did she have actual?
I used actual income for her, Your Honor.
All right. And her actual income, it looks like it's a little bit more than his imputed income.
Mm-hmm.
And that gets put in with the number of overnights, sir, and anything else that's appropriate. The computer spits out the number, and I 99.5% of the time give that number. So I think the imputed income appears appropriate. She is working. Her income is appropriate. The computer tells me that that's the amount. We've not started it until this month, so I believe that the uniform child support order is also appropriate. We'll enter that when it's presented to me through DocuSign. Anything else you want to say, sir?
No, sir.
All right, good luck. Get out there and find a job. All right, and Miss White, is there anything you want to say?
No.
All right, thanks to both of you. Have a good weekend. Take care. Thank you, Ms. Brower.
Thank you, Your Honor. Have a good one.
Judgment, an agreed upon settlement in this matter. I looked through it before. I understand that Ms. Wolfram and her client are present here in the courtroom. The other parties are present by Zoom. Why can't we? I don't care whether it should be, you made an agreement to it or not. I understand, Mr. Van Elderen, what you're stating, and I kind of agree, but I don't understand why we can't figure out what is your client's objection to the order?
I mean, my client's objection was to the specific language of the order, among other things. I don't know if I can, do you want me to paraphrase, or would you like to hear from Mr. Quano himself at this point?
I don't want to hear from Mr. Quano because you're here. Quite frankly, I'm going to be honest in this case. Mr. Quano always got a problem with everything. That's why he lost legal custody. I want to know, Mr. Van Elderen, was that basically the settlement agreement that was reached in that order? And if not, what specifically do you object to?
So, I mean, we had been, Ms. Wolfram and I have been going back and forth. And I think, we've been, based on what my client had said to me and what Ms. Wolfram had said to me, I believe that we were going to be close to an agreement on the eve of the hearing. I didn't know if we were going to be, all the way there.
Wait a minute. We called off the hearing because you guys had an agreement on what to do. All right. And I didn't put it on the record, did I?
We did not put it on.
And that was my mistake. I'm never going to make that mistake in this case again with counsel, because I almost always require that. I assumed that you had reached an agreement and need to put it on and get an order in. Mr. Quano has given up legal custody. That's clear. All right. That was the agreement that was reached, right?
The understanding was that in exchange for that, he would be able to maintain and retain control over the party's religion.
I understand. I'm not gonna, he can, religion isn't part of this anyhow. I mean, he can have his religious stuff with the kids. I'm not I'm not preventing that. And I'm not saying that mother can just dictate religion. That fine. He can expose them to them and listen until it becomes a detriment to the kids. And it's proven to me. I'm not going to get in the middle of religion. And that's in the order, as I understand it, that he's allowed to expose the kids to religion. All right. I'm not going to let him take them to to Jonesville down in Guyana for that kind of stuff. But quite frankly, I don't care if he does reasonable religion, and that's in the order. I'll tell you, I don't like the order because it says that there is proper cause of change of circumstance to warrant parenting time change, because that's up to me. But if an order gets entered, and if somebody asks me to enter it by Monday, I'll sign that order. But if it keeps going, I'm going to go ahead. What do you want to say, Mr. Anero? What is specifically wrong with the order?
Well, Your Honor, I think that's where part of the difficulty lies, is that I was, in my communications with Mr. Quano, my understanding was that in exchange for being able to revisit parenting time and expand parenting time, and continue to be able to exercise his religion with the children, that he would be willing to put this matter to bed. And then upon presentation of the proposed orders, it became clear to me that it didn't seem to be the case. And so I'm struggling with articulating in my own words exactly what it is that he's not in agreement with, because it seems to.
Does it seem like that's what you agreed upon, Mr. Van Elderen, when you were talking with Miss Wolfram? That he gets to be involved in the religion, whatever it is. He doesn't see his kids very much, so I don't know that I don't know how much exposure to religion there is. But I'm not saying that he can't have it. You're telling me that in effect that's what was negotiated. He's not going to have joint legal custody, but that doesn't mean he doesn't have anything. He still gets a chance to see where they go for dentist and all this kind of stuff. He still gets that information. He's just not going to be making that decision. He has been an obstructionist in this case from day one. And all I'm getting from you, Mr. Van Elderen, is that if I read between the lines, it kind of was the agreement, but your client won't agree to it, so you're certainly not going to.
Well, I guess at this point, I don't know. I don't know how if my client's telling me he's not willing to agree to it, to the specific, to these terms. I don't know what I can do at this point.
Well, you can't. I'm saying you can't.
Right, and that's where I'm at. And
Mr. Quano, did you see the judgment, the proposed judgment, and what specifically do you disagree with that was not negotiated?
I did see the proposed judgment. It was very last minute. I had asked.
Very last minute. It's been out there forever. Don't give me this last minute. What now is the problem with it?
I had proposed a very different set of language to my attorney.
What?
And there was very specific graduated parenting time in there that would explain how we could get to
parenting time wasn't agreed to in it. It was the agreement that the parties would work towards parenting time. That wasn't the agreement that was here.
Well, that was
in your mind, you think you're supposed to get it. The agreement was, and I don't even think it's valid, but I'm willing to sign it, that you don't have to prove proper cause or change of circumstance through shade or whatever to increase some parenting time and that they want me to, or you guys to negotiate some kind of increased parenting time.
Well, I offered, and I sent my attorney the proposal I had for a specific parenting time.
Yeah, but
And
that wasn't what was agreed to when our hearing date was set.
well,
A completely different issue.
well, my understanding was, and what I'd heard from the attorney was that there was a pre-hearing consult, at which time my understanding was that you had said that it looked like legal custody would go to her, but maybe we could work out, it wasn't working that I had so little parenting time, and that maybe we could work out some universal solution. One of the things I objected to was that there was no provision for anything substantive on what I would get for increased parenting time, but just some idea that we would talk about it later. And I didn't understand that to be something that would be useful. I figured that in a negotiation, we should try to get what we're asking for at the same time as we're giving something up.
They gave something up saying that they would, in effect, allow the court or whatever to look at possible increases in parenting time. I don't think it's there to do it, but they gave that up. And I'm not going to put that in if we don't get an order right away. I'm not, because that's what the quid pro quo was for that. I just am beyond angry that we have a hearing set. We agreed that you guys agree to stuff, and then you don't get an order entered. And Miss Wolfram, who is here, I think Mr. Van Elderen is probably correct. I know he said, yeah, that's perfect to change in there. But I think it was that he thought that was correct and had to go through his client. And I'm not going to hold him to that. I'm just telling you right now. I understand. I understand.
A few issues that I do need to address, depending on what the court wants to decide, if you want to take it into account. So for instance, the ADHD evaluation is still on hold. That because he interfered with it, that particular provider will not just sort of take our word that we had because we don't have an order. So that is still on hold. It's been more than a year. Those appointments, when the cancellation schedule comes up, he cannot take advantage of them because we don't have permission from Mr. Guano and we don't have our solution.
You have permission from me to do that and to put it in an order. I'm sick of this.
We've already been scheduled, Your Honor. The evaluation was
fine. Then don't say anything because it's already scheduled. What do you want? What do you want? It's scheduled and they're going to be able to go through it. Period. What else?
That was the primary thing, and really just like I said, we are back here again. We canceled. While I understand the argument to that extent, we canceled this hearing on the fact that I had an agreement. And I understand that I know the court understands, and I know Mr. Van Elderen knows that I understand the position that he's in. But we have to have a resolution at some point. We've been going through this for.
That's right. We're going to end up going back and having a legal custody trial, but it's not going to include anything about parenting time. I can tell you that right now. You're going to have to file something totally separate and going to have to prove to me that there's proper cause or change of circumstance to warrant a parenting time revision, because you're not going to agree to stipulate that there is. That's what we're going to go back to. We'll set up an evidentiary hearing.
I'm sorry, there was one more thing I completely forgot. I know that Mr. Van Elderen is working with me, but again, with the difficulties in this case, I had presented to him that the one child has track, which interferes on 5 occasions throughout the season with the parenting time. I proposed to him that just that child be excused and that he have parenting time with the other children and make up those 5 dates with that one child afterwards. I don't want my client to be in contempt for not providing that child.
Your client will not be in contempt for allowing the children to participate in school events. All right. Outside events, maybe, but if the child's in track and whatnot, your child will be allowed to go in there. I'm not even sure that I'll have makeup time. That's just life. That's what shade talks to you about, Mr. Van Elderen. You know what that shade is, and it can modify parenting time. Quite frankly, that's what happens when kids get older. I mean, Mr. Van Elderen, I'm not trying to do anything to you. All right. You can explain to your client what shade is, and that the court, can modify parenting time, certainly based on that. And that the child, and if the parties can agree on some kind of different time or whatever, that's fine. But if he wants to file a thing at the front of the court for a violation, I can tell you what I'm going to do with it right now. If the kid is legitimately in a school event, the kids don't have to pay for the parents not being able to get along. Anything else?
I I think that's it for now. I mean, obviously, we request that we have this soon as possible at the evidentiary hearing because my client's in the process of achieving all these things that she's been unable to achieve because she believed that we had an agreement. So
Yeah, this is, Mr. Van Eldern, anything you want to say? I'm not going to hold you to the fact that you said, yeah, that language is perfect. And I don't think that was a complete agreement at that time. I understand, mostly I understand because, I understand Mr. Kawano, and you could not agree to something without his agreement.
Thank you.
Anything
I have
else?
nothing further to add at this point, no.
no, I think we're all set. Thank you.
Yes, we don't have an agreement, and I've learned a lesson never to accept something that's not on the record from here on out. Good luck. We're adjourned.
I'll provide that order.
Good.
For
Hmm?
evidentiary, that I will have.
Yeah, it's not going to be real soon. I mean, I'm going some and that kind of stuff. If there are issues that come up that he just doesn't agree to, file a quick motion. If I agree to it, I'm going to charge him attorney's fees from here on out. I mean, I'm just.
I will email. Okay, just a little bit. I just figured since I was going to write it, I'd ask you that. But okay, thanks so much. Yeah.
Thank you. Peace. Just drive. Deep breath. Hello, everybody out there in YouTube land.
Hello.
All right, Miss Brown, can you hear me all right?
Yes, I can hear you. Are you able to hear me?
I'm able to hear you. I can't see you. Mr.
Yes,
Scott.
I'm sorry. My camera doesn't want to work all of a sudden, and I apologize for that.
All right. Yes, Brown v. Scott. This is both parties are present on Zoom. Mr. Brown has filed a parenting time motion, wants a set schedule. I don't believe there is any set schedule in the DS order, if you will. That was the only custody order. He makes a bunch of allegations, a fight between the mom and the child. CPS has been called, whatnot. I just today received a response indicating that as of right now, apparently Mr. Scott is out on bond for assault with intent to commit great bodily harm less than murder. Mr. Scott, when's your settlement conference or something on that charge?
June 18th.
All right. And you're out on bond right now, right?
Yes, I am.
Okay. All right. What do you want to say about parenting time?
I just wanted, I didn't want to like try to take full custody. I just wanted to be able to see my daughter at times when me and Miss Brown is not seeing eye to eye. I don't want my daughter to be held against me.
Well, when was the last time you saw her?
It was maybe 4 months ago.
That's a lie. That's a lie, sir.
Ma'am, I'm going to give you your chance.
Oh, I apologize.
And so you say you saw her 4 months ago. For how long?
I saw her for maybe 5 hours.
And before that, you haven't seen her much. I take it sometime. How old is this child?
13.
I'm assuming she hasn't spent a lot of time with you. I believe you've been incarcerated for some of her life too, haven't you?
Correct.
Ma'am, she's 13. He's entitled to see her some. What are you proposing that he be allowed? He's not going to get, 50-50 custody and stuff like that. What kind of time, at least in the short term here, are you suggesting?
In the motion, I just received the motion on the 17th. It was dropped in my mailbox. That's why I just responded yesterday.
Or did you drop it in her mailbox?
I mailed it out, yes.
It was not mailed out. It was dropped in my mailbox. There was not a postmark on the letter.
It was in her mailbox, sir. You or somebody on your behalf?
Somebody on my behalf, yes.
Who was it?
My girlfriend. She mailed it out.
It was not mailed. There was not a postmark on the letter. Someone dropped it in the mailbox. His girlfriend, as he just stated.
So you don't know anything whether your girlfriend put it in the mailbox or in the mail. Is that right?
No, she told me that she was gonna mail it out, but I know that me and Miss Brown don't see eye to eye, so I didn't really want to be the one to come to her address. I didn't want no confrontation. So
your girlfriend go to the address instead?
She told me she mailed it out, but she's been there before numerous times picking up my daughter to bring my daughter to see me.
I don't have a problem with it, but you don't have proper notice.
That's fine. Yeah, exactly. And
ma'am,
I didn't.
Ma'am,
I'm
You
sorry, go
don't,
ahead.
you don't have proper notice, and if she wants this adjourned for 2 weeks, that's, she can have it because she didn't have enough notice. Do you want this motion adjourned, or do you want to deal with it now, ma'am?
We can deal with it now, but that's why
Right.
I.
Well, then it's a non-issue, and we're not gonna spend time on it.
Yeah.
All right. What kind of time? She's 13. She's not a little baby anymore. What kind of time are you proposing that, Mr. Scott have, at least in the short term, because I don't know what's gonna happen once he gets to his, settlement conference and whatnot for his criminal case?
Yeah, I just, as I stated in the motion, supervised visitation is what I'm suggesting because he is violent, as I stated in the motion. He has domestic.
Has he ever been violent with his daughter?
No, but he has a history of violent
I
offenses. He's a known drug dealer. He's a known drug dealer in the community. He's violent. He's aggressive. He's an alcoholic. He's not responsible. And when I have allowed Kamaya to go with him, it's supervised through other family members, his mother, his sister. I want her supervised with him because he's not responsible.
All right, sir, your mom available?
My mom lives in Ohio.
All right.
Every time my daughter's been.
What about your sister?
My sister,
She's a
yes.
flight attendant. She's a flight attendant.
Okay. She's a flight attendant. Sounds like she's got a.
She's in and out.
What?
I'm sorry. She's in and out. So it's like sporadic.
Well, she must have some type of a schedule, and I understand flight attendants. So,
Your Honor, my daughter doesn't even live with her for the simple fact that she's been putting her hands and
that is not
up on my daughter. I have text messages from my daughter letting me on my phone that I can bring in to show.
That's not true.
I've never once been physical with my daughter. My daughter loves being around me.
She's never around you. You're always in prison for violence, drugs.
When did you last get out, sir?
Last get out of prison?
Yeah.
2018.
He just got out of jail February 2nd for the bodily harm, less than murder, resisting arrest.
No, that was probably because he posted.
22nd. I posted mine on the 26th or the 27th.
I gave you the screenshot.
And I am completely innocent on that case. That case is going to be dismissed.
Gosh. He's violent. He did 5 years for strangulation against me, Your Honor. He's
and
violent.
That's the reason.
He's violent.
I've never been abusive to my daughter. Me and her don't see eye to eye. That's the reason.
One of the factors in the best interest of the child is domestic violence, regardless of whether the violence is directed against or witnessed by the child. You've got a history. Apparently, you did prison time for violence against the plaintiff.
Yes. In other charges against other mothers of his other children, Your Honor. He is violent. I only pulled what I could pull off of Otis and I'm sorry, go ahead.
When I'll let him see his daughter starting
Absolutely.
right now.
Absolutely. But I feel like I'm not trying to keep him from his child, but I want my child to be safe. He doesn't have an address. He doesn't have
I do have an address. I do have an address.
Can I please speak?
I'm at home right now.
Can I please speak? I could not find the Trowbridge address. That is not a legit address. Can I please speak? Can I please speak? On the return address.
You guys just go ahead and talk. I'm going to leave. All right.
I just want to let you know.
You just argued.
No, I just want to let you know this. On the return address, it's a union address. So there's so many different addresses that he's at. On the return address of the motion, this is a union address. On the motion, it's a Trowbridge address. On his driver's license, there's a different address. Like there's no consistency. I'm done, Your Honor. I apologize. I'm not trying to argue. I just want my daughter to be safe.
I'll send this to the friend of the court for parenting time evaluation. Both parties need to cooperate with it. I'll even waive the fees so it can go there and you don't have to have a problem with it.
Thank you.
That's just going to the friend of the court. Ma'am, you'll be able to put forth all your evidence and whatnot with the friend of the court. You understand that?
Yes, sir.
I cannot order anything right now other than referral to the friend of the court and waive the fees. Thank you all very much.
Can I ask a question, Your Honor?
What?
My daughter's been running away because of the problems that she's been having at home, and she runs to me. Will I get in trouble if I am a father and be there for her?
He doesn't have any
I'm not going to give advisory opinions. Good luck, everybody. Thank you.
Thank you. Bye.
We're going right down the list.
Oh, man, this is not going good today. Well, Cheryl, what do you think of today? Nice that have joined us, Missy, Allison, Sharon, all the usuals. Hope everybody's having a good day. It's starting out great for me. This is Cato. Is this the one that the guardianship is terminated?
Yes.
All right. Ms. Gill, can you hear me? If so, you're on mute and you need to unmute and turn on your camera. Mr. Straight, same to you if you're here. All right. It's Gill versus Straight.
Yeah.
The case was entitled something different. It was Cato versus Straight before because it's, the guardian was involved with it. Miss Gill is the parent of Isabella and Madison.
Right.
We're in it. I thank you. That was in a guardianship before that was terminated, and now Mom, Miss Gill, is seeking custody. There was a judgment of paternity for Isabella, at least in 2022. In September of 23, the guardianship was terminated. It doesn't appear that custody or parenting time has ever really been set in this matter because of the guardianship.
Yeah, that's true.
So what are you looking at?
I'm trying to make it so their dad can see them every Thursday and every other weekend.
Who has the kids now?
I do. Rachel.
Sir, what's your position on this? You didn't file any kind of answer? What are you looking at?
Just every other weekend and every Thursday.
That's what you're looking for?
Yes, sir. And I pay her $200 a week for child support. So
$200 a week for child support? And this is what
yes.
everybody agrees on?
I do, yes.
Ms. Gill, do you agree on it?
Yeah, I do.
Should have come down and filed a stipulation and order that you guys agree on. On the record, you agree that physical custody to mom. I'm going to give joint legal to both parties.
Right.
Yes, sir.
Father to have parenting time. It's every Thursday from what time to what time?
Let's do
After
3
school.
o'clock.
After school.
Yeah,
till,
after school until like 8 o'clock.
After school till 8 o'clock.
Yeah.
Yes, sir.
And every other weekend, Friday. Again, I'm kind of after school, but you don't want to make the kids take everything to school to go to visit you. So
right.
What, 5 o'clock to Sunday at 7 o'clock?
Yeah, that's fine.
Yes, sir.
Anything else? Every other holiday? Yeah, you guys can figure
That's
out.
fine.
You
Yeah.
guys can figure out the rest. You're getting long enough to do this, so.
Right.
Oh, for sure.
We'll put the order in, figure out if sometime he can take him on a vacation in the summer or something like that, or whatnot.
Yeah.
Get along, all right? I'll put in the custody order, physical to mom, legal, joint, parenting time, after school, Thursdays until 8 p.m. and on every other weekend, Friday from 5 p.m. to 7 p.m.
Okay.
Yes, sir.
Child support would be $200 per week, which I got to put in a monthly amount. So we'll have to, if it's 200 per week, I'll have to multiply it out and it'll be 2 times 4.3 is the amount of weeks. It'll be 400. It'll be $860 per month. That's the way it's set. Is okay.
Yes.
All right.
Easy, right?
Easiest one I've had so far. You're actually
Yeah.
you're making me kind of happy. Let me think. What do you want to, in the child support thing, the order, it will require, do you want to split medical expenses 50-50 that is not covered by insurance?
Sure.
Okay. Does anybody cover the kids on insurance?
I do.
I don't get insurance, so.
All right. So anything that's not covered by mom's insurance is over and above that. You got to split 50-50.
Yes, sir.
All right. All right. You should have, I should make it file a stipulation in order, but because you guys are the winners of the day so far of being actually getting along, I'm going to turn it over to my clerk.
Okay.
All right. You should get a copy of it at your respective addresses. I'm not going to read it because we're on YouTube, but sir, you're 665 still?
Yes.
And ma'am, you're still 579?
Yes.
All right, we'll get that out to you fairly promptly. You guys can figure out when the weekends start and stuff like that.
Okay.
Okay.
Good luck.
All right,
Thank you,
appreciate
Paul.
it.
Thank you.
Thank you.
Yep.
Have
Nice
a
to
good one.
see you. You too.
You too.
Yep.
Miller.
Okay.
Both parties are present via Zoom. There's a child in common by the name of Tyson, who I believe is 10. This is father's motion for custody. We just had a motion 322 with a referral to the friend of the court for parenting time and child support. The only thing that I have seen regarding physical custody was the judgment of support that gave physical custody to the mother. Sir, you say you want, what are you looking for? You have provided nothing to meet the standard for Vodvarka, which is a standard you have to meet for proper cause or change of circumstance to change the custody that's already been determined. What do you have to say, sir? I read your motion, but what do you want to add?
I couldn't hear the first part of it. There was something wrong with the volume, so I have no idea what you said. I just got in at the end part. So I didn't catch anything from the beginning. I was trying to speak. I didn't know if you could hear me or not, but I'm just able to hear now.
There is a judgment of support that provided custody to mother back in 2017. You filed a custody motion based upon what change of circumstance or proper cause are you asking for a change of custody?
I haven't been able to see him. She's been keeping him from me and his family.
Has there been a parenting time order?
No, from what I know, yeah, from whatever she had done before. I didn't know anything about the court and everything. That this is the first time I've ever seen a judge or we spoke to anybody. She knew what my wishes was and what I wanted way beforehand.
So she's got custody and she knows what your wishes are and she didn't agree to them. That doesn't, why haven't you been here before 2017? I mean, it's been
it wasn't about 24/17. I wanted to co-parent between me and her and work things out as far as my child and nothing else.
Well,
it became a problem from what I know, and it was just for child support, which I didn't mind. As for my son, the problem is when I'm not getting him and you're not respecting it.
There was a referral to the friend of the court back on 3/25/24 for parenting time. What, are you participating in that?
I did not get any of that information. I was not sent any of it. The only reason I found out about anything is because I got a Zoom call to my phone and I decided to check into it further and found out that it was being something filed. I had no idea.
You had no idea of what?
Of anything being filed before me getting the Zoom meeting. Hold on, it's a little noisy in here. I'm gonna move on.
I sent this to the friend of the court for parenting time and child support considerations less than a month ago.
Right, and I didn't know about that. And that wasn't me sending that. That was something that was done on her behalf.
It was done on the both parties' behalf because we're trying to find out what is appropriate parenting time. I guess I'm not really following what you're saying.
Okay.
The court is going to do an evaluation of parenting time. They'll send you information. Do they have do they have an address for you? It's in Benton Harbor, I think.
No, the address is up there. That's the mailing address. The problem is that she's been keeping him from me and my family going on years now. And I've begged and pleaded. I want to go in front of the judge. I don't even want to talk to her no more. This is what she wants. This is the direction she wants to go with things. I've been in his life. I've been trying to get him. His family has been trying to get him. She will not give him to anybody. She accepts all money. She accepts all money from everywhere, but she does not give my son to any of his family, and none of us have seen him. So I don't want to talk to her. I don't want to deal with her. I want to go to the judge.
When was the last time you saw the child?
It's been 3 years now.
All right. Why haven't you been here in 3 years then?
Because I did not know. I don't believe in the court system. I don't trust the court system. It's against my beliefs. I don't have a choice but to go through this way. And it's also about information. I didn't have the information that I have now. I do have it. So this is the only way to do it. Now that we're at this point, I don't want to go back and forth with her. I don't want to do no co-parenting. All the stuff I've been trying to do with her all these years, we've been going back and forth. I thought that we could be adults and co-parent with our child. I was trying to keep everybody else out of it. I've stood in the courtroom with her other children. I've seen the type of things that they do. I've seen the type of things that take place. And so therefore I was trying to avoid that. That is not, a lot of times you don't build. It's already bad enough we don't get along as it is. And that's just something else to put in the middle of arguing and going back and forth. And so now I don't even want to conversate with her or anybody. I just want my son like I've always wanted. I've got all the proof on my side over these years for what's been going on, that I've been active. I've been in this life. Anytime something don't go her way, she keeps him from me. And I'm tired of it.
You said she's kept him from you for 3 years.
Right.
All right. Well, I sent it to the friend of the court for a determination of what kind of parenting time is correct. I still have sent it to the friend of the court to determine what is correct. What do you think I'm going to do here today?
I don't know what goes on here today. I don't know that we don't know the process of what happens. Like I said,
you filed the motion.
Talk to anybody.
You filed the motion.
Right.
Well,
and so what information do you need from me in order to send it forward or whatever? What is it that you're trying to come up with now to move forward? What information
I don't give people advice. I listen to what they say and make determinations. I'm not going to give advice on what you need to do. I'm telling you, I sent it to the friend of the court for their evaluation. Cooperate with it. If you do not cooperate with the friend of the court evaluation, all the information I will get will be from her.
Right. That's fine. I get that. I never said I wasn't cooperating with it. I will cooperate with the friend of the court evaluation. What I'm saying now is that what do you need? What information you want from me to, I guess, help you with your decision on what takes place? What I was expecting, I sent it in. You said you read it. What I want is for the next 90 days that I get my son every weekend. And after the 90 days, we split it 50-50. And the 90 days is only to make sure I got enough time to have everything prepared for him. So when he's with me for my time, he's okay. And I have everything that he needs. There is no more. The thing is I don't get any of this time back. None of that time's come back. She was keeping him from me beforehand, before that. Anytime it's something she doesn't agree with. And so what I want is the control to have just as much as control. I want my son. I don't even want to have to deal with her.
Are you done?
Yeah, I'm listening. I'm trying to figure out what the next steps is and what you need from me to prove it. I don't know.
Number one, I don't give advice on when I get from you. That's up to you and your attorney to figure that out. What I get, it's up to her and her attorney to do that. Number two, I referred it to the friend of the court so that they can make some sense and both parties can do whatever they can, provide all the information. The friend of the court will tell you what they want you to do and all that kind of stuff. And at the time that they complete their evaluation, they'll submit a recommendation to the court. If either of you disagrees with the recommendation, you can file within the specific time period that you're allowed. And if you don't agree with it, I'll probably have an evidentiary hearing to determine what is appropriate. That's where the case is right now. As far as you saying you want 50-50, you don't qualify under the standard of Vadvarka for proper cause or change of circumstance to get 50-50 because that changes in an established custodial environment. That is just out there in the law that I'm following. So when you go to the friend of the court, I suggest you follow whatever they need. If they ask you for stuff to prove things, fine. Get it into them because they're going to make a recommendation to me about what is appropriate.
Right, but it sounds like you're telling me what I don't qualify for, but you're not telling me what the qualifications is for that to be moved.
Do you understand? I'm telling you, I don't give advice on what I need. That's
right. No, that's fine. So what do we do from this point? All the information.
You go to the friend of the court, and the friend of the court in the very not too far future will give me a recommendation so that I have some idea. You haven't seen your child for 3 years. I can't stress enough that, if my ex-wife had stopped me from 3 weeks, I would have been in front of the court. Not 3 years. I would have been in front of the court saying, I want that time, not 3 years down the road.
Right, but it also depends
to
on what you
you.
believe in.
So
That's
you're
you.
gonna go to the friend of the court, follow the recommendation about when they contact you. Contact the friend of the court today to make sure they have your correct address, because they're gonna contact you about parenting time and child support. Make sure that they have your address. If they don't have it, they send it and you don't get it, that's your fault, not theirs and not mine.
Yeah, no, they have it.
Well, I'm just telling you, because I had an address in Benton Harbor and you say that's not it, and I don't know if that's what they have. They
It's
probably have.
I said that's a mailing
Because you're
address.
paying
That's
child support. I'm just telling you, if you now come back and say, I didn't get it, and they say, because they're gonna tell me where they mailed it to.
right.
And if you didn't get it, then that's your fault, all right?
Okay.
That's where we're going. So as of right now, there is no other order other than you're going to the friend of the court, and we will be back on this, I'm sure, in the relatively near future when the friend of the court concludes their investigation. And if the parties don't agree on what the friend of the court says, then you'll file an objection within the time period. We'll set up an evidentiary hearing. You'll come in here. If you come in here without attorneys, you're at a disadvantage, but we'll have an evidentiary hearing that is a formal hearing where you must follow the rules of evidence and everything to get it in front of me, and then I'll make a decision. That's where.
Okay. So what was the point of this video call in the first place then?
Your motion. You filed a motion. I had to hear it. I didn't set it up. You set it up.
Okay. Mm-hmm.
Ms. Garber, I didn't give you a chance to say anything, but there's nothing for you to say.
All right. Sounds good. So
Into the court. We'll go there. And
we do already have a time frame for the friend of the court. It was sent in
he just
via
logged
email
off.
and mail.
He just got logged off. So you do what.
Thank you for your time, Judge. I appreciate you.
All right.
I hope you have a great day.
You too. Thank you.
Bye.
Is present via Zoom. This is a motion by the plaintiff mother regarding child support. The parties were divorced just basically a year ago. There was a UCSO where the plaintiff pays $165 for the 3 kids. Looks like the friend of the court was involved. Says the oldest child is no longer eligible for child support. There's a question of they'd had a babysitter that now isn't a mutual babysitter, and child support is based upon having daycare and stuff like that. Ma'am, this is your motion. You've also asked for FaceTime every day. What do you want to say, ma'am? I've read your motion, but
good morning. Sorry. Good morning, Your Honor. Yes, I was requesting to use app close due to it's free and us communicate that way. And then Mr. Grable is using a live-in girlfriend as the babysitter, and I'm no longer using a babysitter. So I'm just requesting.
What do you do with the kids when you have them? Don't you each have 50-50?
Yes, I have worked it around my schedule to be home with them when I have them.
All right.
Your Honor, if I may.
Well, no, let me finish with her and then you'll get your time. Go ahead.
Your Honor, I feel there's no proof that the live-in girlfriend is getting paid. He indicated there's cash payouts. I feel like the money is going back within their household. So I'm just requesting we employ our own babysitters if we use them, and then child support be modified without daycare costs.
All right, sir, you're going to have a tough time if you got a live-in girlfriend that's providing daycare. I don't know why you're paying her for it, your live-in girlfriend, but what's your response?
So she, speaking of the name, she only has the children 6 days during the work week, and she only works 4 days a week. So she would only utilize a nanny or a daycare 2 days a month. She only has them on the weekends. I have them during the week. So anytime we had a nanny, call-offs, whatever, it was she would state that it was my parenting time, and I had to deal with that. So in December, we had a nanny who worked for us who was going back to school. And so in January, we needed a new nanny. In November, we talked, Miss Grable, I, and the new nanny, that she would quit her job. We would pay the same amount of money to her as we were the current nanny, allowing stability for the children who are 5, 4, and 2. And not having to keep introducing new nannies or me have jeopardy of potentially losing my job because I didn't have a co-parent who would also take time off if the kids were sick or if the nanny called out. So there is proof. I have sent Venmo. We have submitted documentation to the courts that I have made payments since January to her because she still has a home in Ohio where she goes on the weekends, 3 out of 4 weekends when we don't have the children. So because she still resides has a house in Ohio and is not a Michigan resident.
So I'm still understanding. Is this a nanny or is this a girlfriend?
She's my girlfriend, but she also has taken the opportunity to work with the children and provide a stable daycare nanny to take care of the children. We do.
How long has she been your girlfriend?
Since July.
I mean, do you understand why I kind of look like you're paying your girlfriend one hand and she's living right there with you? I mean, what?
Yes, I understand that, Your Honor. But part of that was because I'm the only one who employed the nannies because they weren't during the week.
I understand when they were nannies. I don't have a problem with that.
Yeah.
Right? I understand that.
I mean, if that, Your Honor, if that's the case, then we would just have the girlfriend go to work because she quit her job, and we would go and her and I split a daycare facility. If that's her issue. But my thing is I was looking at what was the best interest of the children, and to be able to have someone that's stable and current, and not someone that's in and out, or a nanny leaving because they're going to school or finding a better job opportunity because it pays more than $17 an hour. And like I said, I mean, every time, this is the 4th time we've had a motion since our divorce. It's unfortunately any time that she is frustrated, instead of co-parenting, we come to you. And I asked in November, tried to be proactive for a nanny in January with Miss Grable what to do, and she provided no support. I'm the one who had care.com and trying to find a nanny. We couldn't find another nanny. She reached out, Miss Grable, and said, hey, and I submitted the text messages to the court. Hey, can she be the nanny? Can we do that? So it wasn't just my decision. She knew I was dating her at the time, and she knew that we needed a nanny and someone to take care of our children. And that's what we agreed upon in November. And now here we are 4 months later, and Miss Grable doesn't like that now.
You realize that if I allow your girlfriend to be a nanny, you're going to have to prove not only payments to her, but that she files it on her tax returns.
Yes, sir.
And you're going to pay taxes on it and stuff like that.
We know
that.
Your Honor. Yeah. Hi, Your Honor. So we share 50-50 custody, and we used to utilize a babysitter together. Now I have rearranged my schedule. When I do have the children, I do not utilize a babysitter. So I feel as if daycare costs.
When do you have the kids?
I have the kids Thursday evening, Friday, Saturday, Sunday, 1 week, and then it switches to Ryan. And then the next week I have him Thursday to Monday evening. So every other Monday I work from home.
Weekends.
Huh?
You primarily have weekends.
Yes, Thursday to Monday.
Maybe we should just work it out where we split week on, week off, and then everybody'd have all kinds of expenses for the kids. You'd have them, he'd have them, and then I'd just say everybody's responsible for their own daycare. How about we do that?
I'm okay with that, Your Honor.
Week on, week off.
You exchange every Sunday night at 6 o'clock. He has them for a week, and then you have them for a week, and then he has them for a week, and then I will cancel all daycare because both of you will be responsible for daycare.
Okay. When would this be in effect, Your Honor?
Next week, 2 weeks.
Okay. Our children are 5, 4, and 2.
So what's the problem with that?
Well, just being away that long, we have it utilized for 4 days on and then 3 days on.
When the children are with the other parent, they can have contact, whether it's FaceTime or what, twice. I'll do Tuesday and Thursday that they can have FaceTime. Kids are all right. I mean,
okay. Can we get the app closed so Ryan and I can communicate via app close?
That seems, I don't know why he would object to that. You guys can communicate over that.
Your Honor, I do object to that. I would want to use the app wizard, which was recommended by my attorney and the FOC.
What's it? I don't even know what's the difference.
One's a paid one, and it also records everything for the courts.
I thought the app close was free.
Yes.
The app close is free. I'm looking at the wizard that is
You want
recommended.
our family wizard?
Yes, sir.
You want to pay for it all?
I'll pay my portion of it all. That's fine. I
Well,
don't-
app close has become the new thing because it's free, and so I mean there's
Okay.
no
Your Honor, I don't know enough about it. I just know that
I hate to tell you, I don't know that much about it either, even though I order it half the time. It's a way for people to communicate where there's a record that's kept and stuff like that, and you guys can do that.
I'm fine, Your Honor, with either or.
Yep, app close is how you'll communicate.
Okay. So, Your Honor, so we're doing week on, week off, and then the daycare costs are
Each party's responsibility.
okay. And then the child support will be remodified with that new calculation.
I'll send it to the friend of the court for a child support evaluation based on 50-50 week on, week off. Both parties are responsible for their own daycare costs.
Okay. And then we start this week on, you said
We'll
next
start a week on, week off next week, Sunday.
next week, Sunday. Okay.
Your Honor, question, just because I want to make sure we all understand. Next week, who will get that first week?
No, that's not going to make any difference in the grand scheme of things in life. I don't know. Who wants to start with the first week?
I can, Your Honor.
Give you an extra week to arrange childcare, ma'am.
Okay.
So
Thank you, Your Honor.
We'll continue on until next Sunday. Sunday exchange at 6 o'clock at night, 7 o'clock? What do you want?
7
We
o'clock.
have it, Your Honor, we have it scheduled 6:30 at the police station.
All right.
For exchanges.
That still can happen, okay?
Sounds good, Your Honor.
6:30, which police station?
Kentwood Police Station off Alma.
Yep. Kentwood Police Department. Each party is going to be responsible for their own daycare costs. Correct?
Yes, Your Honor.
And we will use if it becomes a problem, you can always come back and ask for our family wizard, but let's try the app close. Communication will be between those. You each have to download it, get it taken care of. You can communicate through that, and only through that unless there is an emergency. All right. I'll allow telephone, whatever, FaceTime, whatever on Tuesday and Thursday for the person who does not have the children. What time would we make it?
It's been 7:30, Your Honor, that we've just mutually agreed upon.
7:30 sounds good. For a call or FaceTime for each party.
Your Honor, can we do these calls through the app close? Can we keep everything in
That
communication?
I don't know. If you can, you can do it through there. I don't know for sure. If you can do it through app close, do it through app close. Otherwise, just for Pete's sakes, you can't even get along to have FaceTime or whatever on Tuesday and Thursday. But Tuesday and Thursday, I'm going to probably put down each party is able to telephone / FaceTime, whatever. All right. If you can do it through app close, do it through app close. If you can't, I don't know that has a FaceTime type provision for it. I don't know I don't think Family Wizard has a way that you can communicate in a FaceTime sort of way with them. So I don't think any of them does. I think you're going to have to do that outside of it. But you'll have records on your phones of when you try to contact and that kind of stuff. I mean, realizing that these kids are 6, 4, and 2 or whatever, they aren't going to want to spend a lot of time looking at a phone talking to mom and dad. This is more for you at this point because you want to, but you never go real long without seeing or hearing anything of them. So that'll be the order. Week on, week off, starting next week, Sunday, with his being the first week. Daycare costs will be the responsibility of each party. App close will be used unless there is an emergency. In other words, some kid falls, break their arm, you better call the other person because you're taking them to the hospital. It will be a call, okay? But other than that, there aren't very many emergencies that you need to call about. You don't need to have contact. Ava's not feeling good. I might take her in to the doctor. You can do that through app close and then say, I called the doctor and made an appointment and going in at such and such time. That's fine. If it's an emergency, you use the phone. All right. But only for that. You guys don't need any other communication but that. I think I've ruled on everything. Anything
Thank
else
you, Your Honor.
anybody needs? Oh, and I will send it to FOC for child support.
Thank you, Your Honor.
Thank you, Your Honor.
Good luck, everybody. Thank you. Have a good weekend. We're
You
adjourned.
too. Bye.
Our last 8:30.
Well, at least we're on time. We finished our 8:30s here in a minute. But we also got one at the, oh no, you probably put that on the prosecutors. It was set for 8:30 also. Well, are we just about done?
Not even close.
Oh, don't say that. Say we're making progress or something. Heiler versus Mendoza. We have both parties present by Zoom as well as Attorney Ms. Fries on behalf of Mr. Heiler. Both parties have filed a parenting time motion. Right. Looks like Dad, as of 11/7/22, had an ex parte for supervised, but that was rapidly set aside. There's a consent judgment of divorce from just about 1 year ago. The joint legal and physical custody, parenting time for father every other weekend and after school until 8 p.m. Looks like, I think, most days. Some are alternating 2-week blocks. And like I say, both parties have filed for a parenting time motion. Who wants to go first?
Well, if I could start, that would be helpful.
Sure, go ahead.
Thank you. I have had conversations with both parties where they're both agreeing to go to the FOC to get a new recommendation done. I know both parties have some small issues that they want to deal with, but they both have agreed to go, at least that to there. The only concern is that my client is no longer working and the other side has some difficulties financially also, so they're hoping that the court would fund the cost for them to go there and get a new recommendation.
I'll just warn you that I don't take a stipulation to go to the friend of the court. I make that decision and I make that decision only.
Okay, great.
What do we need to do here?
So
your client can't visit like he used to because he clearly works, doesn't he work second shift?
Well, he's not working right now. He lost his job, so there's been a change of employment there, change of income obviously also. I know the other side has stated that she is either getting a new job or changing the hours, so they have talked about him assisting in daycare during the times that she is at work, which will help. The only concern that I have at this point is my client is actually supposed to be exercising Thursdays through Sundays. There is a PPO that Ms. Mendoza has taken out on him. So the concern is when they do exchanges, eliminating any conflict or concern on either side. So the question for my client was, do we do a Thursday through Monday so that they're picking up after school, dropping off at school? So that there's not
extra time just because there's a PPO. I'm not going to give them extra time.
Okay, well, the concern is the pick up and drop off and making sure that they're utilizing appropriate measures during the pickup and drop off. My client is requesting that it be done right off the highway at the movie theater to make it an easy on, easy off, where the location is right now. Instead of McDonald's, which is way down on Alpine. So it's during rush hour traffic, which causes a lot of time and congestion in between pickup and drop off. So they're asking for that to be changed also. My client also is requesting, because he has phone calls with his daughters, basically whenever they want to talk back and forth. Ms. Mendoza tends to pick up the phone and take the phone away from the kids to talk to him. And he just wants that to stop. If he's having conversations with the kids, he doesn't want to have a conversation with her. It causes a lot of strife and arguments, and he's trying to avoid that.
Ma'am, Ms. Mendoza, what's your thoughts on this?
Can you hear me, Your Honor?
Yes.
Okay. Well, first of all, I would like to start off with, I didn't get served with any paperwork, so I have no idea what Mr. Heiler is demanding or asking the court regarding parenting time.
You have filed a motion for parenting time. Talk about your motion then.
Okay. Yes. I don't know if you got a chance to go through my motion, but
yes, I did.
Oh, great. Okay. So with I am in agreement with the friend of the court because I've tried amicably to try this co-parenting thing. It's
right, but what do you want for parenting time?
Oh, I'm asking for supervised visitations because new events keep on arising that now I'm concerned for the safety and if it was in the best interest of the children if they reside with me every night. They stay every night here with me until we go
What is your proper cause or change of circumstance to try and do that?
A few things. Mr. Heiler has just got substantiated by CPS for Matthews, so he's working with them. Another thing is that there has been police activity at his apartment that he has told my daughters not to tell me. There was a break-in about 3 months ago, and this was in my daughter's room, and Mr. Heiler and his friend were present. Thankfully, my daughters were not. So that's why I'm asking until then.
It wasn't police activity with him because there was some police activity in some apartment complex somewhere. You don't want him to see the kids?
Oh, of course not, Your Honor. No, he called the police on his ex-girlfriend who was living there for 3 weeks. She's apparently stole some items. So he called the police, told my kids not to tell me.
But the kids weren't even there when he called the police about his ex-girlfriend? Nothing like that? Is that right?
I'm sorry?
He called the police on his girlfriend.
And my
The kids
daughters were
not
there. No, my daughters, it was his weekend. They were his watch. My thing is, do not tell my daughters not to tell me, or don't tell mom, because that's not correct.
Okay, go on. What do you, I don't see anything where he's got to suddenly have supervised parenting time.
Okay.
You guys have joint legal and physical custody as of a
Correct.
year ago. Okay.
Okay.
And he sees the kids, is it every other weekend?
He sees them every other weekend, and
Until when?
until Sunday night when he's
Friday at what time to Sunday at what time?
he picks up the children from school, which is 4.
All right.
And then he has the weekend with his kids, which that's his parenting time. And then Sunday night at 8 p.m. he's supposed to drop them off, but he has been detaining them for me. He has been taking them on Mondays to school.
Then do
Sometimes
you file a violation with the friend of the court, because it's a violation of the court order if he keeps them too long? You file a violation with the friend of the court, they'll look into it. If he's violating it, I'm going to hold him in contempt and give him some kind of problems.
no, I didn't even know about this motion until my daughter told me. So I went looked it online. I found out. So I filed. I didn't know I can do that, but I'll keep that in mind. So he has.
Keep that in mind. I'm not going to hold him in contempt or do anything. If he's violating a court order, go to the friend of the court and do the established way to take care of that, which is file a violation. And it will get to me if he violated, and it won't go good for him if he's violating the court order unless he has a tremendous reason to violate a court order.
Understood. So
So see the kids every day after school because he picks them up or something?
He does not pick them up, Your Honor.
All
I've
right.
been picking them up. I've been providing for the children 9%. I am the primary, provider. I'm on state disability, and a lot of jobs that I'm looking at, they're not going to. I take my daughters to 2 different schools. One of them goes to a charter school. An hour later, the other one goes to an elementary school.
All right.
So an hour gap, and then to pick them up an hour gap. So no job. I mean, hardly anybody's going to want to hire me for 4 or 5 hours in between.
Fine.
To
We
like
don't
get
have
that.
to go on all this. I'm just asking when he has the kids. All right. He has them every
Okay.
other weekend. Any other time that in the court
No,
order?
he has him. I told him he can get him on his time whenever he can. Just bring him back by 8. He refuses to do so. He does not follow the parental court order at all. He
I
tries
told you what to do if he violates the court order. I told you what to do.
Okay.
So you say he gets the kids till 8?
That's what the court divorce papers say from 4 to 8. So he picks them for school every day and is supposed to drop them off at 8. The time that he has done that, he says nope. He goes, I'm not going to drive all the way back. He goes, so he wants me to change the rules. And I told him, no, we got to follow the court order. We have to do this. So that's his big, he's upset because of the PPO. He's upset with me about everything. So he makes things, if I don't go into his demands, he makes parenting very complex and difficult.
All right. Party's got to follow the court order. End of story. Mr. Heiler, if you don't follow the court order, you'll be in front of me and you can talk to your attorney who clearly knows what's going to happen to you if you don't follow a court order. I mean, it's one thing if you're late for an 8 o'clock something because there's a terrible accident and the road is closed and you contact her and say, hey, I'll be 20 minutes late. That's one thing, but that'll happen once a year at most. It's another thing that you don't get the kids back when you're ordered to get them back. You don't control this. The court order controls it. And if you don't follow it, I will hold you in contempt. I will give some kind of stuff that will not be favorable to you. I'm warning you.
Yes, sir. Yes, sir.
And you have an attorney. You should be talking to her about this because she knows court orders are not suggestions. They're orders. All right.
Yes, sir.
So that'll be it. I don't think there's anything here because you have a PPO and all that kind of stuff. I don't see anything that affects the child to the point where I'm going to suddenly just take his parenting time and give him supervised parenting time. If he's got a meth problem that you say in here, there's a probation violation and stuff like that. Provide me information, provide me proof of that with your motion. And, if he's got a meth violation for probation, it's a good chance that his probation officer will violate him.
Oh, no, that was in the past, Your Honor. That wasn't, no, he's done with all that. Right now, he's just substantiated with CPS. So he's working with them because he was tested positive.
That's incorrect information, but we can address that later.
Okay.
Yeah. I don't see anything here that I would change the prior parenting time order. It's only a year old. It's been going, I think at one point was it your client saying that he was working a shift that he couldn't do the after school or stuff like that, Ms. Fries, is that correct?
Well, there was issues with him doing after school and he asked her to work with him and she didn't want to work with him, but at this point he's not working. Now, keep in mind that up until February, these two were still in a relationship. She actually got the PPO in November. They continued the relationship till February. So he was in continuous contact with these kids up until she served that PPO on him.
Oh, all exchanges will have to take place at a neutral location so that there can be, I don't want him violating his PPO, but there are also, most PPOs will allow for him to have parenting time and stuff like that. We've got to still have the parties do something. Where do they live so that we can find someplace in between at a police department? Ma'am, you live there?
Yes.
And he lives down southeast?
Correct.
What's a good police department for the two of you to meet at that's kind of in the middle so that there is no, I mean, Grand Rapids Police Department down on Monroe? Does that work?
That's fine.
Yes, that'll work, Your Honor.
Exchange at the Grand Rapids Police Department so that there's anything that goes on that's a possible PPO violation, you can walk right in there, either of you. All right?
Perfect.
They probably have cameras there, I'm sure, to see what's going on. This is ridiculous. You guys got to figure out how to co-parent and
I understand.
not come to me. I'm not going to be the super parent that's going to parent your children constantly because you can't get along. Ms. Fries, I urge you to kind of work with both parties. I know you represent Mr. Tyler, but
I have been. I've been texting both of them to try and work it out, try and figure out where they're at and what we can do to negotiate to make sure that they're both protected and feeling safe. And so far it's been going pretty well. We've been communicating pretty cordially. So I'll continue to do that.
So I'm going to deny both parties' motion for parenting time, but I am going to have it that the exchanges that are necessary will take place at the Grand Rapids Police Department, not at McDonald's and stuff like that. All right.
Okay.
At the Grand Rapids Police Department. All right.
Thank you, Your
Honor.
Oh,
Anything
Your Honor, I
else?
have one more issue that we kind of left off with the phone. I just wanted some, the phone, I have never kept on with calling the girls. And what was said earlier is 100% completely untrue. The only time I
Great.
took,
I mean, how old are the kids?
7 and 10.
They're pretty young. I mean,
I just asked that he doesn't think negative.
Just like when you have a Mr. Heiler, and if she calls the kids at that time, both of you got to grow up and let the kids talk to their other parent.
Your Honor.
And a 7-year-old is going to want to spend a lot of time talking to a parent. That just isn't realistic. Not even a 10-year-old. They got better things to do than to talk to the parents all the time. Go ahead. You can have conversations. If it comes down to it, and if I get it back again, I'm going to set a specific time when parents can talk. But it sounds, Ms. Fries, that you can kind of make some.
I'll try to make headway with that.
I'm not claiming that she interrupts or that she doesn't, ma'am. I know you. Let's just come on. All right, you've got your PPO. If he does inappropriate things, we'll do it. If not, work with CPS if you have to, sir. I don't know, but I'm denying both parties parenting time motion. However, I am stating that all exchanges will take place at the Grand Rapids Police Department.
Would you like me to draft that order, sir?
Yes, I would.
Thank you,
Go
sir.
with my clerk, because she'd be drafting it otherwise, and she wants it for you to draft it even more than her.
I will do that.
All right. Good luck, everybody. Thank you.
Thank you, Your
Honor.
This is going bad. I want you all to know. I want you all to know you're not doing well because my clerk just broke a nail with this file, specifically on this file. So you're all going to pay. All right.
Yikes.
Not going to go good for you.
Is that our file?
All right. Camps v. Camps. Both parties are present with the respective attorneys, Ms. Pagorsh and Ms. Baxter. This is a motion from, I got to make sure that respondent, I guess he's defendant, Mr. Camps, to enter an order that comports with the GAL recommendations that Mr. Dunn had submitted. My first question to both of you is, have you talked to Mr. Dunn as what he thinks is appropriate?
I have not submitted our proposed order to Mr. Dunn. He said he told us we would have to rehire him to pursue any further action on adopting recommendations.
You're going to have to bring him in or something, because if you guys can't agree what the order should be from him, he's going to, you're trying to get in his recommendations and order into an order. So you're going to have him be involved in it.
Well, we pretty much cut and pasted our proposed order from the recommendations that he provided for you. So we're looking for any guidance to get this resolved as soon as possible.
Yeah, I've given you some guidance. Get Mr. Dunn involved. and make what it's supposed to be. Ms. Pagorsh, have you been in touch with Mr. Dunn?
I have not, Your Honor. Judy and I tried to figure it out, and both of us have cut and pasted. I added from the order or from the recommendation as well to try and get some clarity and just to clean up the verbiage so that it was clear what the expectation was. So we both pulled from parts of the report. I think it's a great idea to send it to Mr. Dunn. I will send the red line version, Judy, with your permission, and copy you on it. So that way he has what you proposed, what I'm proposing is revised, and he can chime in.
He's the one who, I thought he did an excellent report, and I thought he did a great job with the parents, all right, and with the child. And now I just want to get something entered, and the best way to enter it is with the person, at least him signing off on it, whether or not it's still my case. I'm still going to make the decisions on it. But when you're trying to enter something that he is from him, I want him involved. If you want to go someplace else, I'm still going to, or if somebody says, no, I don't like his recommendation, I'm not going to enter that. That's a different world then. Then we'll have a hearing. Okay. Altogether different world, because it's still my case and I still make the decisions. But you two are effectively agreeing, as I understand it, that Mr. Dunn's recommendations should be implemented. You just can't figure out the wording to implement it. All right.
Correct. Right. Can we ask Mr. Dunn to come up with a proposed order of his own?
You can ask Mr. Dunn, you can ask Mr. Dunn what the weather is up in Traverse City. I don't care. You can ask Mr. Dunn anything you want. Okay.
My thought is, Judy, that would just ask him to recreate the wheel. I think if we sent him your version and my version, he can look at it to see, does he like the ads? Does he not like the ads that I'm suggesting? Or I think for the parties to have to go through and pay a third party now to look at this and pay for more drafting work just doesn't make sense economically.
But at this point,
but that's what I thought we were coming for the referee to do. However, if
the referee punted.
If we ask Guardian Dunn to come up with more recommendations, we'll be in the same boat down the road.
You're not really coming up with more recommendations. You're coming up with what he feels is the appropriate order based on what he put in.
Right.
That's why I'm just at this point of saying that's what I understand. You're not asking for that Mr. Dunn's work, that nobody's really objecting to what he's stating should happen. You just can't come up with the language to make it happen. All right. If you objected to his recommendations, again, I'd have an evidentiary hearing here. All right. Similar to going to the friend of the court. He did a lot of good work on this, and you guys obviously agree that his recommendation should be implemented. Work with him on it. Yeah, it's going to cost you a little extra because the two of you can't agree to it, but talk to him. And if you still get to the point where you don't, I guess I'll have to have an evidentiary hearing or something and listen to everybody talk about everything that should be put in the order, which you don't want to pay that much to do that.
Will you be contacting Mr. Dunn, telling him that you're referring us back to him, or do we?
I'm going to tell Mr. Dunn that I've seen this case again, and these nuts just can't get it done. These two attorneys are a pain in my neck.
Well,
no,
I would be happy if you told him that.
Will you both stipulate to that?
Yes, we'd be happy to stipulate to that.
Right. All I'm really saying, you guys can contact them. If you want me to contact them, I can email them and say parties are coming back to get an order entered.
Yes, I would appreciate if you would do that.
Is that what you want, Ms. Pagorsh?
That's fine, Your Honor. I will send him an email this morning when I'm done with the other hearing as well to say, here's a copy of the order that Judy proposed. Here's a copy of my order. Let us know what
wants him to come up with the appropriate order based upon his recommendation to help come up with the appropriate order.
That's fine. And but he will know that this is a direction from you too. That's
all. He will, but he's going to hear from Ms. Pagorsh probably before me, because at the rate I'm going with this case and every other one, I'll be done about 2:30 today.
Well, that's fine. As long as you do that.
That's fine for you, but it's not for me.
He listens to you. That's the thing.
So anything else that we can do? My order is, I don't know if anybody wants to draft an order based on this. My order is to go to Mike Dunn to see if this matter can be settled. Or
can you draft that order, or do you want me to? It's my motion. Do you want me to draft that order, Your Honor? I can throw that together. I'll have my paralegal just do it. Just that the court's ordered that the parties return to guardian ad litem to assist with the drafting of the order. Okay.
Perfect. All right. Everybody have a great day.
Thank you, Your Honor.
Thank you.
Mary, do you want to stay on?
I will. I wasn't sure how to do that. Thanks.
We're not going to hear your case next, but we're just asking you to stay on. All right. Do I consider this my lucky day that she's on like 2 cases in a row, or do I play the lottery or not?
I
My
wouldn't.
clerk
I
says
think it's
yes.
more like a bad penny coming
Well,
back.
the clerk says I should play the lottery because I got you on 2 cases in a row. Oh,
There you go.
the case of Miller v. Miller. There's a child by the name of, is it Maeve?
Yes.
1 year old. As I understand, both parties are present, as well as Ms. Pagorsh, who, while she represents Ms. Miller, is kind of filled in as trying to get everything resolved, as I put it, and has filed a ROPA motion regarding the 1-month-old child. It's my understanding that at the time of the PROCON that Ms. Miller did not know she was pregnant, but she was, in fact. So the child was conceived during the marriage, and as such, Mr. Miller is the presumed father.
Correct.
Since that time, Ms. Pagorsh, I think we have a DNA test.
We do, Your Honor.
Mr. Ungry, Chase Ungry.
That's correct.
That everybody agrees that Mr. Ungry is the father.
Yes, Your Honor.
Ms. Pagorsh, have you talked to Mr. Ungry? I'm just trying to make sure that he agrees that he is.
Well, he signed on to the stipulation as well. He agrees that he is, and that this was brought to my attention when they tried to put him on the birth certificate and have him sign the acknowledgement of paternity because the closeness with the entry of the judgment.
All right. And so basically you're just stating the obvious that Mr. Ungry is the father. Mr. Miller is not the father of this child. It just happened to happen within a time frame that was right at the time of the divorce. Is there anything else, Ms. Pagorsh, that you would like to state on this matter?
No, Your Honor. I think you have captured it well. Thank you.
All right. It's clear that Mr. Miller is not the father of Maeve, that as such, we would enter the order that revokes his paternity and allows Mr. Ungry then, I'm assuming, Ms. Walters, that Mr. Ungry is going to sign a affidavit of parentage so that he can be the legal father.
Yes.
All right. Then I think I have an attached order here that
You should, Your Honor. We also sent separately 4 additional copies when we filed the motion.
Yeah.
So hopefully those you still have. If you need us to email them to your clerk, I can absolutely have my assistant do that.
if you sent them to me, there's a good chance that my clerk has them somewhere and that and took them from me so I wouldn't lose it. Everything we have is here in the file. We have an exhibit that shows Mr. Ungry is the father. Stipulated order to amend the judgment of divorce for a revocation of paternity. I have that signed by everybody, and I have more than one copy. I don't know how many I got, but I got probably 3 or 4 copies. So I will sign that order and we will return it to you, Ms. Pagorsh, so you can distribute it to everyone. If there's nothing else, this has been the easiest motion I've had for the day. Thank you all very much. You get a star.
Thank you, Your Honor.
Thank you,
Appreciate
Your
your
Honor.
time today.
Mr. Miller, you didn't get a chance to say anything. Anything you want to say?
No, sir.
Good luck to you then, everybody. Take care. We're adjourned.
Thanks, Your Honor.
Thank you.
Good luck with the rest of your docket.
Thank you. We skipped number 9. Number 9.
Guess what number we're on?
Number 9. Yes. Both parties are present with their respective attorneys, Ms. Judd for Ms. Hoyer, Mr. Krupp for Mr. Corbett. The first issue I'm going to deal with is it's clearly improper notice that Ms. Judd has stated. It was mailed out on the 12th. That's not appropriate. Ms. Judd, are you requesting an adjournment? Because if so, I'm going to give it to you because it just does not meet the court rules.
I think that I'm prepared to proceed, Your Honor. I mean, I'm very frustrated by the lack of accommodation, but I've reviewed the pleadings while I was waiting this morning, and I think I'm good.
saying I'll adjourn it gladly because it was improper service.
Ms. Hoyer, I'll leave it up to you. I know we've had a limited amount of time to communicate. We've communicated via email, but if you want more time to communicate,
You can have 2 weeks and you can come back. And
you want to reschedule this?
I feel comfortable to proceed.
all right.
Okay.
Then this is the then you're obviously waiving the defect in notice. Correct?
Yes.
All right. This is the father's parenting time motion filed by Mr. Krupp. This is an extremely similar motion to that which was filed in 2021, I think, in an order from 2/24/22. Mr. Krupp, you say parenting time hasn't been modified for 7 years, but there was a review in 21, 22.
Well, basically, we just tweaked to the order. Nothing really substantial happened. We ended up with basically the same parenting time. We have a child that's 15.
Yeah, but I did review it. Don't
Right.
come up with reviewed. All right. There are Thursday nights in the summer from, I think, he gets every Thursday night, correct? But in the summer, it becomes an overnight?
Yeah.
That's correct. All right. And it has to be returned on Friday. Child has to be returned on Friday by 3. Ed says child wants a bunch of more overnights. That doesn't fulfill Vidvarka, I can tell you that, the child's request. What do you have to say, Mr. Krupp, other than?
Sure, I don't think I have to meet the Vidvarka standard. We're not asking for a change in custody.
If you're asking what he asked the child, according to what I read in there, the child wants added overnights, 1 or 2 per week and week on, week off in the summer. That'd be way more than is required for Vidvarka. If you're just asking for summer or something like that, then it probably doesn't. You tell me what you're asking for.
Sure, I guess what I asked for is actually in the motion. At the end of the day, my client has a Thursday that's not an overnight. This child is almost 16 and will be driving.
He has a Thursday that's overnight in the summer, correct?
But not during the school year. And the child will be 16. I kind of scratch my head because it's kind of like you win the war, but you lose the battle. At the end of the day, the child wants to spend more time with my client. My client wants to spend more time with him. He's almost 16. He'll be 16 this fall. To drive a wedge to try and make sure your child spends no time with the dad is, I can't, like I said, you win the battle, lose the war. The child's going to get really angry and frustrated. They live a half mile away from each other. He's not allowed to even ride his bike over to see his dad unless it's a specified time. It's very straightforward and easy to just merely say, hey, you know what? You have Thursdays out anyway. Why don't we do an overnight? And then
you're asking for 42 additional overnights.
Well,
a minimum, right?
Well, not a minimum. It's pretty straightforward. I'm looking for Thursday
because you're not looking for anything in the summer then?
Well, I'd like to finish. Yes. Rather than doing the Thursday overnight during the summer, just do week on, week off during the summer, which 99% of Kent County has, and the Thursday overnight, and the child's almost 16. I don't think what's being
talk
requested.
yourself into the need for Vidvarka because you're asking for 42 extra overnights plus a significant number in the summer, which is going to be well over 50 overnights, and that meets Vidvarka clearly, and you know that.
Okay, well, that's fine. I guess then we would just want the alternating weeks during the summer. Again, the child will be 16. I guess my client will tell him, you absolutely cannot drive over to my house. Stay away. Your mom will hate you, and your mom, it's just beyond me what we're doing. But okay, then yes, we'd request the alternating weeks during the summer only then.
It's just
beyond me, but.
Well, sorry, but you've got a long time, and it's not beyond you because you've argued the other side at other times. It's not beyond you, so. Yeah, you're representing your client. And he wants every other week in the summer. And I'm not sure how many added overnights that is. I don't know if that would reach Vidvarka or not. Doesn't he get Thursday, Friday, Saturday, every other weekend? And he gets the Thursday night that he doesn't get the weekend. And is this one where he gets 3 other nights every month, not connected to the other time? I mean, it is unwieldy. What is there? Let's clean this up some. And Ms. Judd, I'm turning to you.
Your Honor, I think the court has kind of hit the nail on the head here. We just negotiated the order that's in place 2 years ago. I've read Shade. I've read Vidvarka. I'm not aware of a child aging 2 years as a sufficient change under either case. I understand that Mr. Corbett doesn't like the schedule, but he authorized his counsel to sign the order 2 years ago. I don't believe there's any alleged change in circumstances aside from this child aging 2 years, which is not a requisite change of circumstance. So we're talking about over 80 nights that Mr. Corbett is asking for. It is a change of custody. My client's the primary custodian. This is silly.
It's not 80 overnights if he withdraws the every Thursday night. Okay.
Well, I understand that, but I think
if he's withdrawing that, then it cuts it down significantly and gets a lot closer to Shade. I'm just being practical.
I understand. I think it's a little disingenuous to throw a bunch of darts at a board and see which one sticks, but we did negotiate the summer. We did afford Mr. Corbett weeks in the summer. We did just revise this 2 years ago. 2 years is not a sufficient change in circumstance. There's no evidence here that the parties are unable to work together. There's simply nothing attached. This is just another bite at the apple, trying to chip away at this until we get toward equal. But my client's a primary custodian. This is what the parties negotiated. This is what they have agreed to follow. And it sounds like a case of buyer's remorse, but we're not in a position to redo what we just did 2 years ago. It's simply not appropriate under any case.
All right.
I would ask that the motion be denied. If Mr. Krupp wants to file a motion to change custody, I believe he can do that, but he would need to demonstrate that there's been a proper change in circumstances.
All right, Mr. Krupp, you can have a real brief response, and then I'm going to.
I would obviously adamantly disagree. Again, I'm amazed that somebody would be fighting over something that is relatively benign. And you got a 16-year-old child. I mean, going on 16.
Right, but Mr. Krupp, well, you're just saying she should agree to anything. He wants this.
No, bottom line is
agree to it.
it's consistent with what you just said. I don't think, and I think you did the math, it hardly moves the needle at all during the summer to make every other week versus what he has now, which is this cobbled up chunks of time where he can't actually go or do anything. And that was part of my motion. It's when you have the Thursday overnight, but then you don't have this and you don't have that. You can't go anywhere with the child.
My biggest problem is going to be, hold on. I got a lot of motions. I got to stop everybody here. My biggest problem is that I do think it would be appropriate for you and Miss Judd. Miss Judd, I think it's appropriate that he would have maybe 3 weeks in the summer, because right now he does not have summer. Okay.
He does. No, he does, Your Honor. That's part of the order from 22. He does that. We did that.
He does what? What's he does?
He does have weeks in the summer.
So basically the volume of time wouldn't change at all if you do alternating weeks during the summer. It virtually be identical.
I'm looking at the order. He has 3 weeks each summer. Each party has 3 weeks each summer. So this claim that he can't go anywhere.
Okay, I'm sorry, I'm
sorry.
I'm getting them confused here, evidently.
He already has weeks in the summer, Your Honor. It's in the 2022 order. That was something that the parties negotiated and added. He just wants more weeks in the summer than he currently has. Which,
well, then he has the Thursday overnights, which when you look at the summer as being roughly 9 weeks,
it's to break up the
moving days around. Again,
I'm not going to change the order. The only part of the order that I would consider changing is there a reason, seriously, that he has to return the child at 3 p.m. on Fridays as opposed to like 7 or 8?
I believe that was a typo, Your Honor. It's 8 p.m.
Oh.
No,
it's just not a number.
It was 3.
3 p.m.
In the order, as I saw it was 3. I don't think, the only thing that I would like to have changed is that it's kind of goofy to have him come back at 3 o'clock on Friday. Is there any reason that your client has something that really needs to do it? The only order change that I would make is it would be from on his Thursday overnights in the summer, he could return at the regular time of like 8 o'clock. Is there any reason that it doesn't give him an extra overnight? It just seems like the kid gets up, if dad can be there with him, kid gets up, at 10 o'clock and by 3 o'clock, he's got to go somewhere, as opposed to them being able to go to a Griffins game, not Griffins, I guess in the summer, but you know what I'm saying.
Right now it's free, Your
Honor. On Friday.
I understand.
There's 2 sections of it, the 3 p.m. until 8 p.m. and then overnight until 3 p.m. on Friday. I'm sure there was a basis for that at the time. I'm happy to communicate with my client about that and reach back out to Mr. Krupp if that's the court's direction.
Yes.
I'm not aware of a specific reason why we chose that. I think we chose a time.
Ma'am, is there any specific reason why he has to be home at 3 o'clock on a Friday?
We did 3 o'clock because that was aligning with the school year time period. And that allows, when there's that shift at 3, that we could go and do a weekend Friday to Sunday during the summer.
Oh, all right. You can still go enjoy a weekend. I'll have him returned on Thursdays at 6 o'clock. That'd be the only way you'll be out of there. When you have the overnights in the summer, for overnight Thursday, you'll return the child at 6 o'clock. Other than that, I'm not going to modify. I don't believe there is sufficient reason to modify anything else within the summer parenting time. End of story.
Okay. Thank you.
Kind of crickets there, but who's going to draft? Ms. Judd, I think you should draft it, because I'm denying the motion for change of parenting time, with the exception of on that Friday, when he has Thursday overnights, he can return the child at 6 o'clock. You can then go someplace with him and stuff like that.
So he's not allowed to stay the night at all during the school year, Your Honor. He has to just come and spend like an hour once a week.
When you can talk to your client.
Well, like I said, you win the battle, lose the war. So anyway, okay, thank you.
Thank you.
Thank you. Have a nice weekend.
You too. Matter Stevens versus Burbank. Both parties are present by Zoom, as well as Attorney Johnson, who is representing the plaintiff. This is the plaintiff's motion for basically a psychological examination be performed on the father. Due to significant concerns, I have received a affidavit as well as other accompanying documents, and that the plaintiff is seeking to have the father psychologically evaluated by a Dr. Cunningham or Dr. Can't remember the last name of that one, but I know there were 2 choices given. There are significant allegations against the father, some really bad behavior in his past, including sexual assaults and whatnot. This is a almost 7-year-old girl, isn't that correct?
Yes, Your Honor.
You also have filed an objection to the friend of the court recommendation, which I don't know what that recommendation was, but I can't do anything with that other than set it for a evidentiary hearing. Ms. Johnson, anything you want to add?
Knowing that the court has read the briefing and is advised of our arguments, I would just ask that the evidentiary hearing be scheduled for after a time period after when we can have a psychological and fitness to parent examination. I do know that if the court needs any additional testimony regarding the affidavits submitted or any documentation regarding the medical records we have in our possession regarding paragraph 1, I believe, of the motion and those prior diagnoses, we'd be happy to submit them. I didn't admittedly quite know how to submit medical records.
It's fine.
I didn't quite want to throw those into the public.
This is just a motion. And
Okay.
to do anything else, I'd have to have an evidentiary hearing. Trust me, any evidentiary hearing is going to be outways because we don't have any openings for quite a while.
Okay.
Mr. Burbank, what's your response?
Well, I am just kind of in awe at everything that she had stated in the parenting time objection. As for
parenting time objection doesn't matter because I have to have an evidentiary hearing if either party objects. End of story.
Okay. So I am a father that loves his daughter, and there was no probable cause as to emotional abuse or anything on my daughter. As for sexual abuse and sexual allegations, that was closed and sealed due to the Romeo and Juliet law that was put in effect.
You kind of admit to that happening. Romeo and Juliet wasn't the person your sister?
No, it was a cousin.
A cousin.
There are 2 different instances of assault on a minor.
Is your cousin?
No, that is my sister, but there was nothing to do with that. There was no sexual assault there.
Go ahead with your response.
I have no idea why she would be requesting supervised parenting time at all. I have shown no reason to justify a supervised parenting time schedule. I'm a mentally fit father.
But you get a chance to prove that.
How otherwise would I prove it other than putting myself out there?
I'm going to order you to take a psychological exam through Dr. Cunningham or Dr. Clark, because I think it's more than appropriate at this point. I'll give you an opportunity to figure out which one do you want, Cunningham or Clark. I don't know either of them, so
I don't know either of them either. I don't know the reason why I would even need a psychological evaluation.
There are enough allegations in here, and I'm to act in the best interest of the child. Trust me that if it may come back that you're absolutely fine. I don't know, but there are enough significant allegations that I don't get in many cases that are very concerning. Whether it's Romeo and Juliet or whether it's your sister has said you abused her in an affidavit that I believe in here you also say that he has really no relationship with his parental side, with his family. Is that correct, Ms. Johnson?
Correct, Your Honor.
There's just a lot of, sir, I don't know if I'm not finding you guilty of anything, but there are enough significant and provable allegations that I have concerns. Even if I do, and I probably will order some kind of supervised parenting time pending this, if it turns out that this is all garbage, I will give you more than makeup time. You get all the time to make up. If it looks like you're going to get supervised parenting time, and you will for a period of time, and the psychological and everything that I hear turns out that this is all garbage submitted by Ms. Stevens, like I say,
I will be going for full custody after this at this point because I am completely astonished as to any allegations.
Well, I'm kind of astonished that the first time you were supposedly going to have parenting time, you didn't have enough gas or something and to come down and see your kid.
There was no order in effect at that time, and there was no communication between mom and I about this. It was on a whim. So yeah, I did not have the gas. Not only that, but I was sick and I wasn't going to risk my daughter getting sick and going back with her being sick to her mom, going like extra days out of school, or causing any other drama with her mom.
All right. First of all, I'm going to grant the motion for a psychological exam. The Mr. Burbank has no, in one way or another, as to who it is, hasn't provided something, even though you provided him a copy of the motion. Any choice on that?
We would prefer Ms. Cunningham.
That's fine. It'll be performed by Ms. Cunningham. Now, the great question is going to be, who's going to pay for that?
Your Honor, my client,
It's your motion, so.
yes, Your Honor, my client is willing to pay for the psychological evaluation. She just wants to make sure her daughter is safe.
All right, then she will pay for it. I will reserve final division of it for later, but she will be responsible to pay for it and must prove to Mr. Burbank promptly that, it's going to be paid for. When Mr. Burbank, Dr. Cunningham, which one did you choose?
So I said Cunningham, Your Honor, but I'm thinking we had given two just in case we couldn't get them scheduled. So we would choose whichever one we could get into more conveniently. But however the court wants to proceed.
Sir, do you work?
I'm sorry?
You work?
Yes, by myself. I'm a general contractor.
So you can kind of, because Cunningham and Clark work down here, and I think you live up north.
Yes, sir.
So you're gonna have to figure out an appropriate time. You're gonna have to give him enough notice of this so that he can work a schedule for that.
Absolutely.
Okay. I have a question though.
And
All of these allegations are from old cases before Aaliyah was even born. Why are they being brought up now?
They brought them up. Whether or not I ultimately consider them in the end will be something else. All right. Whether or not they're appropriate or not. I don't know. I don't know either of you. I don't know your kids. I think this is the first time I've ever seen the case. All right. I act in the best interest of the child. If there is nothing that turns out to be of any value, it'll go good for you. If there is stuff of value, then it won't go good for you. I don't know. All I'm doing is telling you, yeah, I think there's enough here to potentially protect the child, and you could do a psychological, and we will. What are you proposing as far as supervised parenting time, Ms. Johnson? I mean, how often does he see the child now? Sir, how often do you see the child?
We just had an order established with FOC of every other weekend and odd even years for holidays and 2 weeks in the summer. We just had that order established.
Is that
And
correct?
that would be the order that has not been entered. That's the objection that's currently
Then
before the court that needs an evidentiary
it's
hearing.
their recommendation, but I got to have a hearing to determine if that's appropriate. They objected to it. So it's not a court order. All right. That's the way this works.
Okay, but that's what we've been practicing for the last almost 2 years now. So
Where do you visit with the child?
at my house,
Who do you live with?
my girlfriend.
Ms. Johnson, what are you proposing? I mean, has he been seeing the child regularly?
So
Fairly regularly?
the child began exhibiting some concerning behaviors back in October.
Has he been
Asking
visiting regularly, pretty much?
sorry, I need to confirm it restarted in February.
Yeah.
So from October to February, there was a gap in him seeing the child. In February, he began seeing the child every other weekend. That's when the child began exhibiting stronger protests to going to visit her father. And that concerned my client enough to hire an attorney to try get an evaluation done and figure out what's going on.
So, Your Honor, I only had one visit with my daughter, and I drove down to Kent City for a daddy-daughter dance at the beginning of March. And then after that, it was March 22nd through the 24th. There was no February visits, so I didn't get to see my daughter from October until, actually, it was like September until February, or March.
Because you had no order for parenting time, right?
Correct.
Why didn't you seek an order for parenting time?
Because I was waiting, and honestly, that was my mistake because I thought there was an order already in place due to my child support recommendations being based on.
No, but if you haven't seen your child for month after month, at some point, I wouldn't put up with it. I'm saying, yeah, I think I have something, but I don't. That's pretty concerning.
So Jolene filed for a motion in November, I believe it was, and all of this was in motion at that point. And she refused to let me see my daughter throughout this entire time. Or
Right,
that
you didn't
entire
have it
time.
because you didn't have a parenting time order. You don't, I mean, there's nothing to enforce.
Correct.
You get it, okay? And you should have been a little bit more proactive on this, but I can't change the past, okay? I can't change the past, whether you saw, whether you didn't, whether, whatever happened in the past. I just can't change it. So, Ms. Johnson, what are you proposing? Because, obviously the friend of the court, I understand you're objecting to it, but obviously the friend of the court thought that there was something that he should have parenting time. Now you want to eliminate it. And like I say, if it turns out that the friend of the court was right, I'm going to give him a lot of makeup time in here, like every weekend or something. He might suffer some for a few months, but you better inform your client that if this doesn't turn out well for her, I'm going to take this into account. I'm going to give him a lot of time, makeup time to see his kid.
I understand, Your Honor. And we wouldn't have filed this motion without the evidence that we feel is sufficient to back it up. The end goal here is just that the child is safe. And if Mr. Matz comes back from the psychological evaluation and they say that the past actions are no longer a concern, then that's great. That's great for the child. That's great for the co-parenting relationship. In terms of supervised parenting time, I know that there are some technical difficulties here because of the distance. And because neither party has a mutual shared person that they believe is safe. I think that Ms. Stevens would be comfortable with Mr. Matt's mother. There could be conversations about family members in Mr. Matt's own family if he has safe individuals that, or even facilities. The only concern is we just don't understand why this child is so scared.
All right. Sir, I know it's not easy for you. Who do you propose? Because there's such a long distance here, I don't want the kid to, you can see her for 2 hours, 3 times a week, because you can't be driving down from there 2 hours, 3 times a week. And I'm recognizing that. Okay. So if I were to give you some parenting time on Saturday or whatever, who would you propose would be somebody that I could say would supervise it? If it's your mother, she just have to be there during that time, and I'll give you, the whole day or something. Give me somebody who is a mutually agreeable person that would be there.
Honestly, I don't have a mutual agreeable person because
who would you propose other than your girlfriend?
Well, that's the only person I would propose because she has full custody of her kids and she has a 50-50 split and a good relationship with their kids' father. I don't have a relationship with my parents, with my mother, so I don't really have a mutually agreed upon person.
I mean, I can give you time down here at the public place or something like that for every Saturday, if you want, from 10 o'clock till 4 o'clock every day at the mall or some place. I'm just trying to find something that can satisfy you're seeing your daughter, and I'd like you to see her every week, because you're not getting overnights or anything right now. But I need to have something in place that is, I mean, like if you're at the mall, I'm not worried there. If you're at Denny's restaurant, I'm not worried there. I'm not requiring a specific individual, but give me some kind of proposal, help me, or else it's not.
The mall would be fine down there. The mall would be fine up here. It's just going to be really difficult to commute every week down there. So.
And I understand that. And I'm trying to make some accommodations for you. That's why I'm asking you, right? How about every other week at Rivertown Mall for 6 hours? I don't know. Your daughter will get tired of being there probably, but you can take her to the movies. You can take her to the food court. You can spend some time there. And I'd give you every week, but I don't think that's practical because I don't think you can travel that much. Right? And I don't want to set it up for failure because you call and say, I can't see you. And mom says, your dad's supposed to come down today, but he's not coming down. Right? That's just not good either.
Right.
So
I'm okay with them all.
You want to do every other Saturday? From what time do you want to get here, sir?
As soon as the mall opens. I'm not sure what time the mall opens.
I don't either because I don't go there very often, but how about we do, how's 11 o'clock sound to you?
Sure, that would work just fine.
11 o'clock till 5 o'clock every other week at Woodland or at Rivertown Mall. And Miss Johnson, you can work with him enough to, if he says, hey, this is getting to be a drag, can I go here or there? You can contact her and try and get someplace other. I mean, we'll do the Rivertown Mall, but I mean, if this lasts for very long, you're going to get tired of going there and you may want to go someplace else. You may want to take her to Craig's Cruisers for hours and stuff like that. All right. I just want you to see your daughter from 11 till 5 every other Saturday and to just have fun with her. All right. Till we get to the end of this. All right. Till we get to the end of this. And then we'll look at it at when that happens. All right.
Okay.
All right. Then you can remind me if everything goes good for you that I told you you'd get some makeup time because you will. All right. I mean, you may end up having a lot of time with her for some time. All right.
Okay.
I'm assuming that this week would probably be pretty quick for you to start. Do you want to start this? Why don't we start it next week, 11 o'clock, Rivertown Mall, meet at the, what? I don't know, Rivertown Mall.
Well, Your Honor, this would be my normal weekend with her.
You want this weekend instead?
I would do this weekend. Yes.
All right. I was just thinking it was going to take you longer to get it going. So, we can do this weekend, 11 o'clock. Where do you meet? What's a spot there? Like the food court or something? Give me
sure.
Or the
food court would be fine. The main entrance at the back of the mall would be fine. The main entrance at Dick's Sporting Goods would be fine.
Want to do that? Main entrance at Dick's Sporting Goods?
Sure.
Good.
All right. And that'll be the exchange at 5 o'clock also?
Sure.
You'll remain on the mall property. You can go to a movie. You can do this kind of stuff with her. Hang out with her. She'll probably like some of the places you'll take her. But
Your Honor, can I ask one additional thing?
I
don't think it's going to be too complicated. I think it should be mutual for both parents, but that neither parent discuss the ongoing.
Yeah, don't discuss what's going on. I mean, mom's saying, I'm sending your dad for a psychological because
Right.
I'm afraid he's a, sex offender. And sir, I don't want you discussing anything with her. Just enjoy your time. All right. Don't discuss your mom's trying to keep me from you and stuff like that. Because if so, then she's going to say, well, yeah, it's because your dad's got a really bad past. And
right.
That's not, we got to keep the 7-year-old out of this stuff. Okay.
Your Honor, my daughter has voiced that her mother is telling her stuff about our case that I don't approve of.
Right. That better not happen, Miss Stevens. Better not happen.
That's a lie.
And well, I don't, of course you're going to say it's a lie and he says, it doesn't make, I'm not going to determine that today. I'm just telling you, if I find out that it's happening, it will not go good for you. If I find out, sir, that you're doing these things, and I will tell you, ultimately, I'm going to interview this child. All right. So, neither of you better be doing this. Just let him have his time with his daughter. It's in a public place. There's no problem with that. Every other week, 11 till 5. We'll get to this as quick as we can. Sir, Miss Johnson is going to contact the psychologist, if you will, to set up an appointment. She will be in touch with you so that, because you got to be able to get there. Okay. But you can't put it off very long because if you do, it's going to become your problem. I'm ordering this be done.
No,
right?
Absolutely. I would rather do it faster and prove my side of the case.
All right. Ms. Johnson, set it up as quick as you can. And Mr. Burbank, if you find that she's not setting it up for, well, it's going to be 5 months from now, you come back on a motion and we're going to find somebody who's going to do it quicker. I'm not going to wait for this. All right.
All right. I appreciate it.
All right. Ms. Johnson, you'll draft the order.
Yes, Your Honor.
And make sure that when you make an appointment that the appropriate payments are arranged by your client.
Absolutely. And then how would Mr. Burbank like me to contact him regarding these appointment or regarding the appointment?
Via email.
Are you comfortable sharing what email address I should use?
Not currently, no.
Well,
you're not comfortable sharing that? Okay.
I don't want you sharing it right now because we're on YouTube.
Okay.
Exactly. We're on YouTube. I don't want to share it on YouTube.
But you, sir, need to contact Miss Johnson right after we get off so that she can get that. All right. You should have her office number. Do you have it?
I can look it up on Google. That's not a big deal.
All right. It's the Crayvelt Law Firm. I can tell you it's 285-0808.
Okay.
And you need to contact her promptly because if you don't, again, any delays will be your fault then. Okay?
Yep.
All right. Good luck, everybody. Thank you. Have a good weekend. We're
Thank you,
adjourned.
Your Honor.
Ms. Mullins is present with her attorney, Ms. Dykema. Mr. Butler has never been present. I need to know if he was served appropriately. Ms. Dykema, do you have any idea how and when he was served?
I know it was mailed to him. I'm not sure exactly when it was mailed, but
Ma'am, do you know when you mailed it to him?
if she's looking at her mother across the table.
Who mailed it to him? You or your mother?
Her
Your
mother, sometime last week.
When last week, ma'am? Mother?
Tuesday or Wednesday. Tuesday or Wednesday.
Tuesday or Wednesday of
They went
last
to the
week?
court. Because they went to the court themselves last week.
Right, well,
And then I just was hired, well, actually haven't been retained, but was filed an appearance on their behalf yesterday.
You say, your client says it was mailed to him on the 9th, which was last week, Tuesday. Is that your best recollection? Because it sounds
She's
like,
shaking her head, yes.
because it sounds like, well, it's your client that says that she mailed it, but apparently her mother did. All right. It appears
They were
that there's
together.
appropriate service on this. This is plaintiff's parenting time motion. I think Dad has supervised parenting time at his mother's. Referral
He's supposed to.
8/30/21 for child support, custody to mom. It was in the paternity order. Says she wants child to remain with her fully. Dad emotionally and verbally abusive in front of his daughter. Dad doesn't follow court orders, keeps the kids. Ms. Dykema, you need to tell your client that if he does not follow court orders, then she needs to file with a friend of the court. I'm not going to do anything about it. Any violations of parenting time orders, she needs to file that with a friend of the court. Says Dad doesn't get prescribed medications. Dad fights with others, wants to suspend parenting time. Ms. Dykema, I know you filed late because I just got your appearance late, like 5 o'clock yesterday.
Yeah. And I still haven't received a retainer, but I did it on good faith because I've represented them in the past. So she doesn't have any money for this, but I did also, in the time we've had this morning, prepared a proposed order. And it's been emailed to you. I don't know if it's been printed, if Tracy printed it.
Why am I going to suspend his parenting? If that order suspends his parenting time, I don't know that that's going to happen.
Okay, well, let me explain then. So what's happened is she has not had any contact other than one FaceTime phone call with her daughter since Easter, Your Honor. One FaceTime call on April 13th that lasted approximately 17 minutes. So he has just had a pattern of, he has no respect for court orders. He has continually just kept her when he feels like keeping her. And then unfortunately, Michaela gets sucked in by him. There's been such a long history of domestic abuse here. She gets sucked in, and then he takes the daughter, and there's no supervision by paternal grandmother anymore either. She is no longer living at that house, and I have absolutely talked to her about filing parenting time complaints, but she'd already been doing that. In fact, we have right now as many as 6, I believe, outstanding parenting time complaints, some by him, some by her, because these two have just kind of been playing games with one another. After he doesn't bring her back for some period of time, and then she refuses to let the child go because there's no promise that she'll come back. There's no promise or assurance that it will actually be supervised pursuant to the court order. But she then kind of gets sucked in, like she even, there's been so many together and then break up, together and then break up, and then she'll suspend or terminate the child support even other than the state support and in waive arrearages, or most recently, even while they were together, he swindled her out of a couple $1,000s from her tax refund, saying that he needed it for property taxes. So, and then refused to bring the child back. We think that he still has outstanding, he was incarcerated for 8.5 months in Texas for fleeing and eluding. He was then released on bond, as far as we can understand. They're going to hire somebody to track that down a little bit further. But this guy has such a long history of criminal record and just disrespecting the law. I don't know how many bench warrants there's been for child support, but multiple. And so what I'm asking for in this order is that, yes, that we have law enforcement help go get the child back. And if there's any question about it, obviously we're trying to protect her from irreparable harm and from him fleeing. He's threatened before that he would go to Canada.
He has the child's birth certificate and social security number, but there is no passport. So in the order, I'm asking that police enforcement agency be involved as well, that the parenting time be suspended, but that he be allowed face.
Hold on. I'm just having a real tough time because they've been together and not together and all this kind of stuff. What is the latest parenting time order that is out there?
The one that you just suggested was August of 2021 was the one that you can see in your file that I prepared, and then subsequent to
when the order went in.
Pardon me?
September 14 is the date of the order that says supervised parenting time. Defendant shall have supervised parenting time with the minor child. Blah blah blah. Saturdays at 6 p.m. until Tuesdays.
And then subsequent to that, they came in without attorneys, and you ordered that the exchange point be at the Citgo gas station.
Yes, I do. Yes. Okay.
So that was the only other order since then. But
who has custody? Is it?
She has full custody. He
Is
just has parenting time.
Is that from the paternity order only?
Default judgment of paternity. Yep.
All right.
That was.
Yep. Let's see, from the paternity.
When was that?
Well, it's probably from 2019.
That was 8/21 of 2019.
That's just standard paternity. All right.
They were broke up for 2 solid years, and that was during the time that we got the court supervised parenting time order in August of 2021. So there was just been this brief period in February to March 8 where she stayed with him for a while and then gave him $2,000 on February 28th.
And this is a 5-year-old child, right?
She just turned 5 in December, which even that he kept her from her 5th birthday party, for instance, with all of the family waiting when he had promised to bring her back. Party was at
Can't
3
do
o'clock.
anything about that. And your client needs to follow through on whatever it is that has to happen, like filing violations. If he doesn't bring the child back, the orders are the orders. They're not suggestions. They're the orders. And she has to do that. All right. I have no problem if he has kept the child since when?
Since Easter, so March 31st. She's only had one FaceTime with the child.
I have no problem ensuring that the child be immediately returned to her, and that if by whatever means, if we need the police to get involved, do you know where he lives?
Yes, in
Do you know where
Rockford.
the child is?
We think that that's where the child is. We don't know.
Does the child attend any kind of preschool or kindergarten or something?
No, she just turned 5.
All right.
Do you have my proposed order in front of you or no?
If you emailed it to me today?
Yeah, I just have been drafting it while I've been waiting.
Here.
And so what I can explain it to, so just what you've just ordered is in there as A and B.
Your order to turn over minor child and suspend. Then is Karen assisting with her is ordered, yes. To effectuate the order, Kent County Sheriff's Department, Grand Police Department, Michigan State, or any other law enforcement agency jurisdiction. Found custody, correct. Defendant's parent.
Maybe the Rockford City Police too. But the Kent County Sheriff's Department has been involved multiple times, but they've just made it clear this is a civil matter. So with this order, they'll be able to actually make sure that she can come home to mom.
The defendant, you're offering. Well, then I'm not suspending if I'm allowing journeys once per week for 1 hour.
I guess you can either write on this order or I can submit another one, but we could say accept that, because I'm allowing FaceTime and journeys.
Because he's clearly violating a parenting time order if you haven't seen him and you haven't seen your child in a month.
Right.
I'll allow FaceTime. Parties shall use app close to communicate. That's appropriate. Defendant shall be allowed supervised parenting time at journeys 1 hour per week until further order of the court. That's fine. We can have a hearing. I'm not going to send it to the friend of the court. I don't know what the friend of the court's going to do anyhow. He's not.
Well, there's 6 pending.
Yeah.
There's 6 pending complaints.
Yeah.
Okay.
They'll be dealing with that. I'm taking the H out. Or does
Just gave you
do you want to?
some.
Do you want to just send me a new one that takes C and H out?
Yeah, I just gave you some.
Do you want to just send me a new one that takes C and H out?
Yeah, I just gave you some.
Do you want to just send me a new one that takes C and H out?
I can, or you can scratch whichever you prefer, and you don't need J or K then?
This order is effective. The parties shall appear before the court on blank for an evidentiary hearing on plaintiff's motion. You mean on what motion are they appearing on?
It's just the motion that we're hearing right now, so I can just take J and K out too if you want and send you a new one.
Send that one and J and K you can take out.
Okay.
And if you get it here and early this afternoon or something, we'll sign it.
Can I email it by this afternoon, or do I have to come down there? I mean, I can otherwise.
What else have you got to do today? Jeez, oh Pete's.
Because I've been here all morning.
I've been here all morning and I'm going to be here for hours yet. You can email it. You can email it.
Okay. On section B, may I add the Rockford police as well?
Yeah, whatever police force will help out.
Okay. And then just for the record, can I state on the record that I'm also requesting post-judgment attorney fees under MCR 3.206 in the event we have to come back, and I just want that to be stated. She is unable to bear the expense of this action, and he is able to pay if with nothing else, with the $2,000 he just got from her.
I'll deal order attorney's fees now. I'll reserve it for some time in the future.
Yeah, I just wanted on the record that I asked for it so that if it comes up again.
All right. We got that. Said if you'll send me that order, I will sign it and see where we end up. We'll set up probably going to need an evidentiary hearing at some point, I'm guessing.
Yeah. Well, that's why
you want parenting time suspended, or I don't know what you want in the long term, because quite frankly, I just want people to follow the court order. It's probably not a bad court order that he gets the time, but it's a bad order if he doesn't follow it.
Right. Well, I guess it'll be in his court, I suppose, if he's going to go to Journeys. Then if he wants something more than that, he can file something. I'm just trying to make it as cost effective as possible.
I'm not going to put up with him just keeping the child. That's a violation of the court order. It's a violation of the court order if your client doesn't or hasn't allowed it. Your client better participate in Journeys 100% and get the child there when is necessary. If she doesn't participate, that's not going to go well for her.
Right. She has withheld the child. I'm not saying she hasn't, but it's been because of the reasons I already stated. Concerned about
that's again, it's not appropriate to withhold the child. I'm just telling you they're court orders, and I'm going to enforce court orders. All right. You should have come in probably earlier, but and said, hey, he's not doing this, but it doesn't matter. You need to file with a friend of the court, because ultimately it'll end up in front of me unless they resolve this matter. It'll be in front of me on contempt for failing to follow the court orders. And if you haven't done it, you're going to be in contempt. If he hasn't, then I'm going to be trying to figure out what to do.
Again, maybe just for cost effectiveness, I'd ask again, it wasn't in her motion, but maybe having the friend of the court take a look at it, because if they do an investigation.
Friend of the court's going to do an investigation on the complaints. And that's what,
you're right.
They will investigate the parenting time complaints, and they do a good job of it. And if they don't reach an agreement, it'll be in front of me on some Tuesday or something afternoon, and we'll deal with it there. That'll be
good.
Good luck. We'll look for your order soon.
I'm sure that I'll just make these changes real quick, and the parties can, or she and her mother will run it down right now, I suspect, so that we can get it in. Are you right in your courtroom? It's not a background, that's your courtroom?
Maybe.
I'll have them run down right now with the order.
All right.
And copies.
Yeah, and if we're out of the courtroom by then, or if you're having problems, call 632-5104. My clerk will answer. We'll come get you at the locked door or something like that.
Beautiful. Thank you very much. Have a great weekend. Hope you get done soon.
Thanks. Hope so too. Sean Cox.
Right,
Everybody's waiting for Sean Cox to appear. Sorry, Mr. Swears, but Sean Cox is a YouTube favorite here. All right.
I can certainly understand why, Your Honor.
They like it that he shaves his head instead of having that big bushy hair that he's used to. All right.
You look at my head and you just say to yourself, just stunning, just stunning.
That was one of the words I hadn't thought of, but it's a great one. Smith v. Lewis. We have both parties present with their respective attorneys. Mr. Swears for Mr. Smith, Sean Cox for Miss Lewis. This was a motion filed by the father regarding parenting time. Let's see. Looks like there was a stipulated parenting time order back in 2016. Summers for dad every other Thursday night. A number of things were in there. Dad wants now week on, week off. Is that, he wants week on, week off throughout the year or what? Mr.
Just in
Sweet?
the summer, Your Honor. This is only a modification of a couple of weeks overall time throughout the year. So it's just solely a summertime.
Because he gets every Thursday night right now, right?
And then, yes, and then during the summer months, Thursday through the end of the weekend, so it becomes an extended,
Right.
there's some additional time sprinkled in there,
And
but you do
then-
the math. it comes down
And then
to
he gets
around-
every other weekend, as well as 3 consecutive overnights in June, July, and August, which are not to be taken attached to the other kind of times and stuff like that, right?
Correct, Your Honor.
All right, Mr. Cox, what have you got to say? I read your response and everything.
Sure, Your Honor. Thank you. Your Honor, my client was properly served in this case. It's just she was served at the very last minute. She could be properly served, so she only retained me Monday. I only say that because once she did receive service, she made several efforts and in fact met with the father of the child in this case to try to resolve the issues. As you see in my response, there are a number of issues concerned, but I think the case is resolvable. But we've got some moving parts here, Your Honor, and I'm not going to obviously reread my whole motion, but we've got to deal with the cat issue. And again, I think that's something fixable. And the child is the captain of her club soccer team, as I indicated in my response. And she, over the summer, will travel all over to Indiana, to Ohio, Pontiac, Michigan, Portage, Michigan. So it's a big deal to her. And then finally, the third kind of moving target we have here is a very challenging relationship with the father and his girlfriend, to say the least. So, but I think this is a case that we could resolve. I think Mr. Swears and I could potentially resolve it if we had a chance to sit down with our clients. And, you know, if that is not something acceptable, I would suggest that we perhaps go see Jane Dykema. Mr. Swears and I have had good fortune with her on complex or heated parenting time.
I should have kept her on. She was the last attorney on, just here.
Oh, yeah. So, but what I'm saying, Your Honor, is that I believe this case is resolvable. I just think it's better to do it in some sort of collaborative process, because it's just trying to resolve some of the underlying issues here, again, that I think are fixable, needs to be done, you know, rather than say, hey, let's go to every other week. I think there's some issues of concern here that we can tackle. And my client has, again, presented some options to the father, but he said, hey, I'll just see you in court. So,
so your suggestion, you're basically suggesting I send it to mediation.
Yes, Your Honor.
All right, Mr. Swears, that's pretty good idea for me. But
briefly, Your Honor, I think two things. One, I won't belabor it. I know the court's had a long day and would probably like to get lunch at some point. I do want to, at least for the record, point out that defendant's response is just flat wrong on the law in this case. I'm not going to belabor it, but we don't do a best interest hearing and then determine threshold. It's the other way around. I just want to put that on. But if defendant's version of tried to work this out was within 5 minutes of receiving service of this motion, called and cussed my client out for an hour, threatening him as a bastard who is trying to destroy her life for an hour and has engaged in that repeatedly over the last week.
I don't really care.
That's not an attempt. I don't know that domestic relations mediation is going to be effective in this case. If the court does order it, I would ask that the court also set it for an evidentiary hearing after that time, just so we have a backstop before we get into summer. Mr. Cox and I do have a lot of success historically working these out. I'd like to be cautiously optimistic. But in this case, just given the events of the past week, I think having a backstop of an evidentiary hearing would be appropriate.
all right. I mean, some of these issues that Mr. Cox talks about, I don't want to get into them too much, but Mr. Cox, you talk about a 3-year-old police report on domestic violence. That's not going to pay much with the girlfriend. That's 3 years. I mean, I read it. Asthma, the cats are there when the kid's there anyhow. I'm not really sure, but I think with Mr. Cox's suggestion, I think, and I want to get it done soon because summer's coming. All right. Then by mid-June, we got to have an answer on this. All right. So, and I'm not sure that if I just set it for a straight evidentiary hearing, you'll get an evidentiary hearing before summer starts. Quite honestly, the only chance you got probably of fixing this in the meantime is doing mediation. Why don't we order mediation? I don't know if the two attorneys can't just figure it out before you get there. Is there a person that we should appoint as a mediator?
We would certainly agree to Jane Dykema, Your Honor.
Mr. Cox?
Yeah, I think she would do a great job for us, Your Honor.
All right. Why don't we order mediation with Jane Dykema? The only reason I don't want to go to her is if she says, gee, I got nothing, I'm gone and I'll be, back in July. I want something to be scheduled soon. All right. And the two of you, I mean, if the two of you can't figure this out, then this is not rocket science. We're dealing with the summer. I will tell you that the overnights that are 3 overnights and stuff like that, separate from other times, that's kind of goofy. Let's get something scheduled that's straightforward and gives everybody some time with the child in the summer. How old is this child? 11.
11.
Yeah, 11. All right, she's starting to get older. Let's get some of this stuff done. All right. And so I will order mediation with Jane Dykema. We can look at putting something on the books, but it's not going to be real soon for. Yeah, we're way out into the end of June. And when you go to mediation, if you settle that thing and don't tell me the day you settled it so that we can take that off and give it to somebody else, you will both go in the deep, dark hole of being the last on every motion from here on and harassed every time you get on here. You're not even the last now. Okay. So imagine, you will go into the black hole of Tracy's list of who are favored attorneys. Yeah.
What I'd ask, I suppose, Your Honor, then is probably a better way forward is just in the interest of checking the box. If the court will make a factual determination that threshold has been met, I don't think we'll need to reserve the evidentiary hearing. We'll file for a temporary order if necessary. And I'm certain Sean and I will be able to work out either with Ms. Dykema, or I'm sure we'll be able to select an alternative mediator if she doesn't have availability.
You're telling me the threshold for a parenting time has been met? I mean, look at shade is a real low standard for it. I'm not really sure it's been met one way or another. We'll deal with that if you come in, because you still have to prove it when you come in. I don't make an evidentiary factual finding here. I just make enough that I think it's worth having an evidentiary hearing. You'd still have to prove it. If we go to an evidentiary hearing, you got to prove that shade has been met throughout your proofs, or else, because the first thing I'm going to say in an opinion is, no, I do not believe that there's proper cause to change the circumstance, so I'm going no farther. Or I do believe there's proper cause, because that'll be based on evidence. I don't have evidence to make that finding right now. I just have preliminary stuff that I will put you on the schedule for an evidentiary hearing at the end of June. We'll contact both of you. Dude, what's the last one?
It was June 24th at 1:30.
Do you want to put on the calendar June 24th at 1:30? I know Mr. Cox generally takes the summer off.
He has to maintain the tan, Your Honor. No, that works, Your Honor. If that's how the court prefers to schedule it, that's
the first schedule we had, and otherwise it's well into July. So
no, I understand, Your Honor.
Mr. Cox, are you all right with that date too, in case we have to go to that? You have to come back from your summer home.
Sorry.
Because we're not going to do it on Zoom. You're going to have to be in here.
You mean, wait a minute, I'm supposed to be in Martha's Vineyard that week. I can't.
I'm pretty sure that is. You'll be in here in a Hawaiian shirt. Probably.
Mr. Swears didn't even believe that when I said that. You're on the 24th is fine for me. Sorry about the short. But Mr. Swears is young, so he doesn't have old guy short-term memory problems. Your Honor, was that 1:30 on the 24th?
Yes.
Thank you.
And I'm older than the two of you put together.
Oh.
You'd be lucky. That we'll put that on the schedule and send out a notice, but I don't expect we're going to need it. You really do got to figure this out. This is not that difficult for just the summer. If you were changing everything, I'd agree with you. Please work together, and you're both still the parents of this child, and I want you to be parents, and you don't have to like each other, but you kind of got to get along. All right. Don't put this child in the middle of this stuff. Good luck, everybody. Have a great weekend.
Thank you, Your Honor. Have a great weekend.
Thank you, Your Honor.
Who's going to draft that motion, by the way, Mr. Swears?
The order?
Since you are the one who filed the motion, I think it's probably.
I'll draft it, Your Honor.
All right, and send it over to Mr. Cox for his approval.
Yeah, and I'll reach out to him immediately after this so we can get mediation scheduled.
Great. All right. Like I said, the last case before this was Jane Dykema, so I know she's in her office right now. Good luck, because she's drafting an order right now. All right. So you should be able to get in touch with her. Good luck, everybody. Thank you.
Have a great Your Honor. Have a good weekend, everybody.
I believe it is.
Thank you, Your Honor.
Both parties are present, as well as their respective attorneys. My biggest fear for the day was that I was going to have to announce the name of the plaintiff, and I have not a prayer of what it was. Ma'am, what I know your name is different now, but what's your name? The former name. All right. Well, that didn't come through, but both parties are present with their respective attorneys. Ms. Maltby for the plaintiff, for the defendant, we have Mr. Christensen. This is the father's parenting time motion.
The reverse of that, Your Honor. I
The reverse
represent
of what?
the defendant.
You're here for the defendant?
Yes.
Great. Had a 50-50 shot at it and got it wrong. All right, so you are the moving party.
Yes, Your Honor.
For the father, parenting time motion. Back in 2023, got parenting time and journeys. December was getting expanded without journeys. Now wants every other weekend and every other week in the summer. I think I do have a letter from a therapist, doesn't give me a lot of help. But, what else have you got to say? I've read your motion. What else do you have to say as far as parenting time?
Thank you, Your Honor. Yes, parenting time has gone very well and has been exercised as indicated by myself as well as opposing counsel in his response. Twice a week, all but I believe one visit has been exercised. The minor child does look forward to that time. Other children's half siblings of the minor child, other children of the plaintiff, also attend this parenting time on occasion, and all are able to spend time together. There, is continued concern for some incontinence issues, which was one of the reasons why plaintiff brought these concerns before the court initially. Unfortunately, that apparently has continued, although I don't feel, the rarity of that is in any, connection to any time with dad. There's been, no medical diagnoses. As you indicated, the therapist does not have much to say on, with those concerns.
The child's a little bit, doesn't want to open up a lot, but that's okay. I understand what your request is, and I've set up a graduated schedule for more and more parenting time. I guess I don't mean to cut you off, but can I hear from Mr. Christensen as to what his thoughts are? Because I intend to proceed at least with some more parenting time and more I think, isn't his right now in the community? Has to be in the community.
That is correct. Yes.
Mr. Christensen, I'm to the point where I haven't seen any problems, and I'm going to start allowing him regular parenting time. What is your thoughts on this?
Your Honor, it has kind of been a confusing situation because the therapist really didn't give a whole lot of insight as to why the child is having incontinent issues. And I'm not trying to paint the defendant as something that he maybe not. I don't know, Your Honor, and I think that's the difficult part here is that as long as this child's been going to therapy, she still hasn't opened up to this point. I think my client is concerned that it did stop for a while, and then it began again when I think when the visitations were more one-on-one, like in a even going to a public setting. Again, I'm not trying to accuse anybody of anything, Your Honor, but something is happening here, and it's not a physical problem. So the mother is just at a loss as to what do we do until we solve this puzzle here, and I think she just wants to to put certain precautions in place so that for her own peace of mind. Until I guess a little bit more disclosure comes forward from the daughter. If this could be something else. It could be like the therapist said. It could be a bully. It could be a lot of different things.
There's a bullying issue and stuff like that. Maybe it relaxed during some time and we're back. But I understand. I don't see any direct connection between that until it gets. Father has gone and done everything he's supposed to, working his way back in. I don't know that there is any direct connection. I appreciate Mr. Christensen, you saying that there may be, but there may not be. Okay. I guess I could say the same thing. Maybe it's related to something that's going on at home too. How do I know? I don't know. So, I'm really inclined to start moving more towards a regular parenting time. If things occur, things occur. If the child opens up to a therapist and you think there's something there, but he's been doing this for going on almost a year, very limited parenting time, and has followed through in what he's supposed to. There's nothing from the therapist that says, oh yeah, wait a minute, as soon as we expanded it, things started happening. And so I'm really inclined to start having, maybe not every other weekend, but getting close to that now. So anything else you wish to add very briefly, Ms. Maltby?
Just to echo what you're saying, Your Honor, it is an unknown, and that's unfortunate, but that's the reality. Mom initiated this particular therapist and has chose to keep this therapist around for a year. And if that's, not successful, then, that was mom's choice to have the minor child with this therapist. And mom's also choosing to send her other children at times to spend time with the defendant and, all be together. So I can't find that there's any, trust concerns, or there wouldn't be other children being involved with my client. And also the child enjoys this time. If there was any, kicking and screaming, we would have, opposing counsel would have responded with that.
I understand. And Mr. Christensen is being really fair and honest, and I really respect that, of not just coming in and screaming and hollering and saying, it looks like as soon as we started this, incontinence started again. I don't know what it is. So it's my intent to institute a every other Friday from after school until Saturday at 8 o'clock, as well as every Wednesday night from 5 till 7. I think the parties are close enough together to do that. At this time, see what happens. That's for 3 months. If at the end of 3 months, there's nothing that can be specifically pinned on father's parenting time, I intend to go to every other weekend. I intend to go to, again, the Wednesday, maybe overnight. We'll do I think we should be doing holidays now. I would hope that the parties can alternate holidays. And in 3 months, April, May, June, we're probably going to start to get to the point of instituting some type of week type of parenting time during the summer also. Not necessarily right now, but we're getting real close to it. And if there's something that really comes up, I'll deal with it. But that's my intent, that starting now, he would have every other Friday overnight till Saturday. I don't know if the best time, can the two of you figure out the best time that he starts Friday, whether it's, I always hate to have a kid have to take their stuff to school so that the dad can pick up from school. Can we do 5 o'clock on Friday till 8 o'clock on Saturday and his weekend, as well as 5 o'clock till Sunday and every Wednesday for 3 months from today's date, which is the 19th, April, May, June, July. As of July 19, if there are no objections filed by you, Mr. Christensen, or something, I intend to go to every other weekend from Friday at 5 till Sunday at 7, we'll say, as well as every Wednesday evening. I'll leave that to you. I'll leave it at 5 till 7, but counsel, if you really think I probably won't do it right away, but we'll do that. And if you start to want some other time, please both counsel work together, because there will be a couple holidays in there and we need to start doing holidays also. All right, in the order, if you're not just going to agree on it.
Okay, Your Honor. Would there, on the Friday nights, would there be a third party there at all? Just because, in case, I don't know, just, will there be another person there other than just the defendant? Do we know?
I would expect that the party getting the child would be responsible for the transportation. What do we need as far as?
Well, okay, in the event that this problem, I guess I'm kind of doing it for both parties, I suppose. There at least could be somebody that can confirm that nothing was going on during that time period, and then that would be better off, and it could probably accelerate the parenting time if we know that there's a third party there, at least during these overnights. And if the incontinence is happening, but there's a third party there, so we know nothing is happening while the visit is going, then we have an idea that it's unrelated to Mr. Hernandez. Does that make sense, Your Honor?
It makes sense, but quite frankly, he's only going to get 2 out of 14 nights, and the incontinence is happening at her house, right? Because he's not having overnights and hasn't had since last June. If she finds something's going on, she can deal with it. All right. But I guess I'm at the end of having him supervised and stuff like that, because I have no real reason to have him supervised anymore. I don't know if he does he live alone, sir?
I don't know.
I have roommates, which are a couple, and they have a child as well.
Oh.
I imagine they'll be around and whatnot.
Yes.
She has a
And
place.
the child is 10 years old. And yeah, she has a place to sleep.
I understand she's 9, but she's going to be 10 in September.
Correct.
And, I assume she has her own room or something like that, or whatever.
Yeah, she has her own space.
All right. Let's just see what happens. And I understand what you're saying, Mr. Christensen, but I really think that, if I can't imagine that if it increases, that it won't increase at her house also, and she'll say, holy smokes. All right. So let's just deal with it.
Okay, Your Honor.
All right. Ms. Maltby, you won the motion, so you get to draft the order. Please send it through Mr. Christensen, who is more than reasonable and will be happy to sign an appropriate motion approved for entry. And if it's not, he will be happy to object to it.
I will do that. Thank you.
All right. Good luck, everybody. We're moving in the right direction. Thank you to the both parties. Thank you.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you. And Mr. Mitz, can you hear me? Michael, you're on mute. If you can't hear me, you're talking to nobody. Michael, can you hear me? Does it show he's connected?
There we go, sir. Yes.
All right. We're here in just a minute, I gotta make a Mitz v. Wieringa. Both parties are present via Zoom. We have a child that we're dealing with. I think it's Ira, who's 11 years old. This is mom's motion regarding pickup, drop off, and communications. I read mom's rambling motion, kind of a stream of consciousness here that she doesn't want any contact with you, which is fine. This is, I don't know, there's no problem with that. To have some type of a place where there's limited contact with you, sir. You filed a response. I read that too. Really, this is just for pickup and drop off. How often do you exchange this child?
He is typically, until recently, he was at my house until Monday morning, and I would drop him off to her Monday. I would pick him up from her house from school on Tuesday, and then her house on Wednesday. Drop him off to her house on Wednesday. Pick him up from school on Thursday, and then drop him off to her house on Friday morning and school from Friday, and then I would drop him again off at her house on Monday. Now she is utilizing a greater proportion of her parenting time at this time.
All right. Ma'am, what do you want? Just, you want something in place where he stays in his car when he drops the child off, and you guys have no contact. When you have to drop him off, you stay in your car.
Yes, that's fine with me.
You have a problem with that, sir?
I do, Your Honor. Miss Wiersma has a history of sleep issues, and when there is not a third party available, i.e. her partner, Miss Wiersma is not typically awake. I've gone to pick him up from her residence, and Miss Wiersma, I've been able to enter Miss Wiersma's residence.
You're not going to enter her residence anymore. That's not going to happen.
No, Your Honor, I do not want to either.
You're not going to do that. The child is 11. The child's not 3 that I'm worried about. There's no reason that the child can't go to her residence, knock on the door, and if nobody answers it, he'll come back to you. If he can't
We've always answered the door.
You don't need to, I got this, okay?
Okay,
If there's nothing, if there's nobody there or whatever, then the child will come back to you. And vice versa. Neither party will get out of their car during exchanges. Neither party will discuss anything with each other will not have any contact with each other during the exchanges. Sir, if you're there and she's there, you guys don't talk to each other, you both have phones, you can record it. I'm not going to put up with any contact between the two of you other than dropping the child off. All right? You understand that?
Yes, Your Honor.
Ma'am?
Yes, Your Honor. I do have some resources that I was given called Safe Connections, Our Family Wizard, and something called Close App. I'm looking into those.
App Close is the same as Our Family Wizard, but it's free. That's the way the parties will communicate with each other. You can both sign up for and be involved with App Close, APPCLOSE, I believe it is. And
yes.
You can communicate that way. I don't have any problem with that. You communicate through App Close. Neither party shall have contact with the other at the exchanges at all. If so, I'll consider that a violation of the court order and I will deal with it appropriately. All right, so either party will stay in their car when they do the exchanges, because I think you do them at the other person's house, don't you?
Yes.
All right. The only other option is we pick a police station where you guys will exchange.
If it comes to that, I'm fine with that.
Well, what do you mean? If it ever comes to that, I'm not putting that in there. I'm just telling you that otherwise we're going to go to something like a spot where you're both going to have to drive to all the time. At least one person gets to stay home and, accept the child, and then, it just goes back and forth. Otherwise, you're both going to have to go to something. So I will state that for the order that neither party shall engage with the other party during exchanges, that they shall remain in their car during the exchanges and have no contact with the other party. And that the parties will communicate through App Close. You both have a week to sign up on that, figure out what it is. All connections will be through that app close, if you will, unless it is an absolute emergency, which means if Ira falls and breaks his arm and you grab him and go to the hospital, you'll call the other person, all right? Other than that, there are not going to be emergencies. You will communicate through the app close app. And no communication strictly except as it relates to the child. Is that clear to everybody?
Yes, Your Honor.
All right, we'll get that order out to you.
Your Honor, I do have a question.
What is it?
About the non-disparagement clause. Ms. Wiersma has been recently investigated by Child Protective Services for disparaging remarks, as well as talking about him about inappropriate behaviors and suicidal ideation, sexual abuse. She has been severely degrading me as a person and as
You have
a
it in
father to our child.
you have it in, there'll be no disparagement of either party by the other party.
Okay, yes, Your Honor.
Thank you.
Understand that to both of you, it's mutual.
Yes, Your Honor.
Leave this. This is an 11-year-old child. Leave him out of it. All right. I don't care what you guys like or don't like about the other one. Leave him. Let him be a child. Pete's sake. All right. You know what he's learning right now? He's learning how to be parents by the two of you, and you're setting a horrible example. All right. So it's about time you grow up and be parents and I don't care whether you hate each other, but you'll get along at least during this kind of stuff, and you won't say bad stuff about the other. Let this kid be an 11-year-old kid. You understand?
Yes.
Good luck. We'll get the order out to you. Thank you.
Thank you.
Sir.
Is that all?
That's all.
Okay, thank you, sir.
Thank you.
Not sure.
We'll get rid of you. Don't worry. Wish we weren't on YouTube right now. Yeah, we are. Both parties are present via Zoom. This is a motion by the mother for custody. There was joint legal custody. And it shows that the parties in 2019 shared custody, at least it does on the UCSO. Each party got 182 overnights. In 2020, there was a UCSO child support order that shows that mom didn't have any overnights. On the allegations are that in March 31st of this year, the father punched the child in the face. An ex parte was signed by Judge Hillary, giving mother extended parenting time. Obviously, that's mother's primary thing, is that her son, and I do have pictures of her son's bruised face, also presented, and Judge dealt with that. Are there any further, Mr. Spearman? I know you gave excuses that I'm just going to tell you right now do not make common sense, that you didn't know that you were punching your son in the face when you did it because it was night.
No, it wasn't the fact I didn't know I was punching my son. I punched my son one time, Your Honor, and that was during the dark. After I chased the guy.
That's what I said. You said you didn't know you punched your son.
No, I didn't. I was chasing another guy out of my house.
Why would you punch your son then?
Because my son was, I don't know. That's what I'm saying. I woke up to this. When I came out of my bedroom, it was a guy upstairs in my house. I never seen this guy before a day in my life. He was opening and closing the door at 12:30 at night in my house.
You said he was upstairs in your house, right?
Yes, where my family sleeps, my kids.
Okay. And then you ran downstairs and he was holding the door, right?
It was pitch black downstairs in my house. I had no lights on in my house. When I got downstairs, the boy ran out he ran out my side door. It was still another person standing at my side door. I punched the person at my side door. He said, "Dad, wait, it's me." I did not hit him no more once he said that to me. I stood over him and I got to asking him, "Why do you have somebody in my house? Who was that boy?" And then I told him I had to go put some clothes on because I was in my underwear.
I read your whole brief, your whole answer. All right. And I understand you went up and got clothes on, and eventually your son was over at the mom's house.
No, that's still not making sense, because as soon as I left outside my house, my son was in the car with his mom. He left with his mom. How was my baby mom outside my house? This is something that has me so confused. Like, what was going on? What plan was supposed to happen at my home while I was sleeping? Because out of 11 and a half years, I never hit my son. I never abused my son. I've always had custody of my son. Man. I never did anything like this. But when I'm waking up to a complete stranger in my house and my house is pitch black, that is way beyond belief. And then for my son to go get in the car with his mom, that's even more skeptical, because why is she outside my house while all this is happening? And I have all the timelines to prove everything that I'm saying.
Ma'am, what's your response?
My response is I was not outside. I was at home asleep,
and my son called me and told me, please, mom, come get me. And that was about like 12:30. I have Elijah here with me too, if you need to speak to him.
No, do
That
not
could-
come there and do
that-
not have him in the room at this point. This is a parent issue.
That couldn't be true
Okay.
because I woke up at 12:30. I have everything timestamped from
Are
the
the
time I
police
called
invest-
Yanni.
Ma'am,
Yes. The police
ma'am,
inve-
ma'am, are there police investigations, CPS, whatever? What's going on at this point?
They dropped it.
From what I know, CPS has spoken with Greg, but that's pretty much all they've told me.
Have they talked to Elijah?
They did talk to Elijah like the day after. Like when I called and they came to us, that's when they talked to Elijah.
All right. So what are you asking for? Obviously,
I'm asking.
Obviously, if it's shown the dad punched his son without good reason, that's obviously Vidvarka to have a hearing. I'm not changing custody right now, but to have a hearing regarding custody. And I think Vidvarka has met enough to look into it, not that it is proven at this point. I think at this point, does Elijah still go to the same school even from your residence, ma'am?
Yes, he does.
Is Elijah doing any good at school?
Yes, he is.
All right. Well, I can't fix this today because I don't have enough facts, if you will, one way or another. I got you claiming that Elijah, you're saying Elijah called you after he got punched?
Yes.
And Dad's saying that's impossible?
That's definitely even the Child Protective Services, Lucas, his name was Lucas. He left even a paper with me. And what's his name? Lucas DeLay. He came and he even spoke to me and he went over the timestamps and everything. He saw I woke up at 12:30 midnight to somebody opening and closing doors upstairs in my home. I don't know what was going on. I don't know what was planned. And I also have that my son made it from my house after running out the house. He made it all the way back to 44th and Byron Center in less than 15 minutes. He had no time to call my baby mom to come pick him up or to let her know the story. She was already outside. And even the Child Protective Services guy asked me, do I feel like I was being set up? And I put that in my paperwork. I feel like I'm being set up by my baby mom and my son because that's no reason why I should have to wake up to a stranger in my home.
Ma'am,
Your Honor, I have a letter from his sister explaining what happened too, because she's the one that went and picked Elijah up from his dad's house.
Sir, nobody interrupted you. Don't interrupt. I give you your opportunity.
Okay.
What, ma'am?
I have a letter from his sister explaining that she went and picked Elijah up after he came and grabbed him from my house.
What does that have to do with this?
I'm sorry?
The sister said that what?
She went and picked Elijah up from Greg personally from his house after I had already released Elijah back to Greg once I had picked him up from Buchanan and something. By the time I got to my son, only thing he had on was some basketball shorts and some bubble sandals. So how would I have been outside waiting for him? When I picked him up from like 28th and Buchanan because it took me some time coming from my house, which is on Byron Center and 28th Street.
Well, we got a lot of things going back and forth. Is all I know.
Your Honor, if I may speak, when I got my son back to my house in Child Protective Services, and this is the reason why the detectives dropped it. Detective Johnson dropped the whole case because for the simple fact, when I got back home with my son, until the time my sister came and picked up my son, I was on the phone with Antoinette, and she's the one made all these allegations while she was on the phone with me, and I have timestamps of that also. We was on the phone until she left with my son. So why would she make up these lies on me when she was on the phone?
Well, it's apparent that I'm going to have some kind of an evidentiary hearing to figure this out because I don't have any phones. I don't have any timestamps. Everybody can present their evidence. I just don't have anything.
I have all the evidence I need. Child Protective Services, Lucas, he even told me that he don't see no reason that it should be a change in the living conditions. He found my house very livable. And like
I understand, that's not the argument. Okay. I
have all the timestamps. I have everything that I need to prove that I was set up inside this situation. That everything happened from 12:30 to 1 o'clock. Everything happened within 30 minutes.
And I'll be
So I'm
happy
not
to take a look at it. We're gonna try and get
Yes,
you in here as soon as we can for some type of a quick evidentiary hearing.
yes.
Have some proofs. You know, you really might want to talk to an attorney about this because
I have no problem with that.
because an evidentiary hearing requires that I follow the rules of evidence. Okay, so when you go to
Yes.
your phone or something, you got to know how to do it because I can't help you. Okay.
No, I have it printed off, sir. I have everything.
I understand, but
printed off.
that's just it. You're telling me that, but that isn't necessarily the way I get to look at it. It has to be properly presented to me in an evidentiary hearing. I'm just warning you, okay? Because if you come in and just say, hey, look at this, I might not be able to do it by
No, I know.
the
It'll
rules
be
of
like
evidence.
Exhibit 1, Exhibit 2, Exhibit 3. I've been
Yeah,
through this
and you have to
situation
identify
before.
and do all this kind of stuff. I'm just warning you ahead of time. Same for you, Miss Arnold. You're gonna come in here, and if you come in by yourself and he comes in with an attorney, you're gonna be at an extreme disadvantage. We're
Well,
gonna
I'm getting an attorney.
yeah, and I hope so. All right. Pending this here, we're gonna get a hearing as quick as we can, and it may only start out with like an hour and a half or something, because I just got to get a handle on this. All right. My clerk probably has an address for both of you. I'm not gonna read it all because we're on YouTube, but Mr. Spearman, are you at 2233?
Yes.
All right. Miss Arnold, are you at 2445? Ms. Arnold?
Yes.
All right, just so I know, because we're gonna send
Yes.
something out really quick to try and get you in here, even if it's in a week or two, to start presenting something. You better go talk to an attorney. Until then, I'm not changing anything. I'm gonna get you in soon. We're gonna get to the bottom of this as quick as I can. And if somebody is, you know, saying stuff to me that are lies, it's not gonna go good for you. All right?
That's perfect. That's very perfect. I also have a question.
I've been doing this all day. What is your question? Please make it brief.
If it comes up that I was set up, am I able to press charges against this matter?
Sure. I can't give you that kind of advice. I can't give you advice against her, and then she asks me something and I give you advice on what to do to him and this kind of stuff. All right.
No, it has nothing
That's
to do
where
with
that's
him.
where you go and you talk to an attorney or a police officer or whatever. Nobody files charges on their own. You have to file it through like a police department or something like that. So you go ahead and do that. We'll see you in here as quickly as we can. Make sure you bring all your evidence, and I would bring an attorney with you too.
That's perfect. Thank you.
What, ma'am?
I have a question too.
Oh.
Are you telling me that I have to take Elijah back to Greg now?
There is nothing that changes until I have this evidentiary here. All orders remain the same because I don't know what the bottom line is. So nothing changes until we get in here, and then I expect a lot of things to change. All right?
Okay. Am I allowed to bring Elijah to court that day too?
Are you allowed to bring him into court?
Yes, that day. For the
He's not
hearing.
gonna sit in the courtroom. I can't stop you from calling him as a witness if you have to. I can't stop you. I don't like to have a kid be a witness, but we'll deal with it at that time. That's where you should be talking to an attorney, because I'm not making you any promises one way or another. I can tell you that while the hearing's going on, he's not gonna be sitting in here. I can tell you that.
Okay.
He's sitting out in the hallway if you bring him. Good luck, everybody. We'll see you soon. Thank you.
Yeah, thank you.
It's a matter of Mamba versus Ernest. We don't have the plaintiff present. This is the defendant's motion regarding child support. Sir, when did you give this information, this motion to the plaintiff? How did you get that to her?
Yes, the way I get that to her, because I came over there to the courthouse, and then they give me the paperwork, and then the same day about they give me the paperwork, and then I mail them to Samba the same day.
The same day?
The same day.
That was back on 1st of April?
Yes, please.
All right, and you did
because I didn't have the address, so the court himself, they helped me to find out the address and file. So then they give that to me, and then a phone number. So and then that's the way I submitted the paperwork to her, and then I even sent out a message. I say, you know what, we have a call date, me and you, on this date, which about today.
As long as you tell me that you mailed it to her and you found out her address in the court, right?
Yes, please.
All right. Then it apparently proper service, and she has not appeared at any time during this. This is the defendant's motion regarding child support. There was a UCSO that was put in place on 3/4/22, which shows $359 that the defendant is paying for 2 kids. Motion asks basically for me to explain why he pays child support and what his rights are with his kids. Correct?
Correct.
I don't know what you want. The child support is calculated by the computers based on incomes and whatnot. And that's what it is. As far as what are your rights with your kids, based on whatever the court orders are.
Yes, my right to the kids, and the reason why I filed this motion is because, you know, I don't understand why I'm paying child support while I'm doing everything for the kids, you know, to me and then the mother. And then on top of that, so the reason why, and then I even end up asking her the same question again. And she told me
you're ordered to pay child support because of the amount of money you make, the number of overnights, the amount of money she makes, it's calculated. And there is no reason not to enter that order. That's all there is to it. Simple as that.
I understand.
You are ordered to pay child support, and I'm not going to change it based on you saying I take care of my kids. That's what your responsibility is. They're your kids. You got to pay child support.
Okay, I know they are my kids, but I know they are my kids. And then for me, the way I understand the system, if you pay child support if you don't take care of the kids, but if you take care of the kids, what they made them to pay child support again while taking the kids?
No, go. You pay child support based on the fact how many overnights you have, this kind of stuff. End of story. You're ordered to pay child support. Everybody pays child support like that. You don't have any reason not to pay child support.
For me, I want you to explain to me the main reason for
I'm not going to explain stuff. You pay child support based on the order that orders you to pay child support.
I don't understand. You know, you told me that the order is to pay child support. If you don't support the kids, I know you gotta pay child support if you don't support the kids. But if you do support the kids, why the main reason to pay child support while you are supporting the kids?
Because it's ordered by the court, and I don't have any reason to change it. That's it.
That's the reason why I wanted the defender to be here, because me and her, we have an agreement, because the system put me on child support while we are doing a co-parenting over here, which don't make sense.
I'm telling you, there's a court order to pay child support. You pay child support unless something is modified. There's no reason for me to modify it. End of story.
What is modifying?
End of story. I'm not going to modify it. There's no reason to modify it. I find no reason to modify it at this point. There's no change in circumstances to modify it. That's it. That's the explanation. Good.
You make no sense at this moment.
I make perfect sense because I do child support every day, and I don't care if you don't. I don't care if you think you shouldn't. You are ordered to pay child support, and unless there is something different that you put in front of me, you can't just come and say, "Why do I pay child support?" You pay child support because there's a court order. End of story. I'm done.
What are you requiring for me to put in front of you? Tell me so I can bring it to you.
I don't give you that information. You put it in front of me. I'm not your attorney. Go hire an attorney.
I'm not going to hire an attorney because I know I'm right about this case.
Go hire an attorney if you want some. The order will remain in effect. I'm not giving advisory opinions. It is done. Good afternoon, sir. I wish you.
They are not good about your afternoon right now. It's nothing good about your afternoon right now, because I know you are not making no sense at all.
Take you off the screen because I've given